a capias was issued. That was failed to appear for a status hearing on April 17th of this year.
Don't talk.
And that court issued a capias when you failed to appear and ordered that you be held no bond pending further order of that court. Now, you do qualify for the public defender. Would you like for me to appoint the public defender
Yes,
for you?
Hornsby, I believe.
Who is it?
I think,
I don't have him no more.
Oh.
He got me into the Veterans Court, that's all he did.
okay.
Did you say you're in Veterans Court?
Yeah.
Okay.
I had, when I looked the case up, what do you have, Madam Clerk? Do you still have Hornsby appointed?
I do.
He has Hornsby still, Your Honor. He has a private attorney.
Okay.
He has not withdrawn from the case.
So that the private attorney is still representing you. Your attorney is not withdrawn from the case.
Okay, I don't know what that means.
Well, that means if you, you want to speak to somebody, you're going to speak to the private attorney. That's going to be helping you in the case.
When will I be seeing the judge at,
When will you be seeing the judge on the failure to appear? Well, I would imagine that once Division 12, where the case is pending, or was pending, or Veterans Court, one or the other is going to set up some kind of a status hearing to get you in and talk to you about the failure to appear and where the case is going to go from here.
okay.
All right, good luck, sir. Good afternoon. Your name?
Tiaka Rhymes.
All right, Ms. Rhymes, looks like you're here for an arraignment on a charge of driving while license suspended or revoked.
Yes, Your Honor, the offer to resolve the driving while license suspended is an adjudication of guilt, credit, time served, and court costs. And Ms. Rhymes would like to accept and enter a plea of no contest. Your Honor, as far as the fees are concerned, could we do a year from date of release? She has other charges where she's not getting out, and to give her time to find employment when she is released to pay the court fees.
Yeah, I have no objection to that. So, Ms. Rhymes, you're entering a plea of no contest to a charge of driving while license suspended or revoked. Is that correct?
Yes, sir.
And do you believe it's in your best interest to enter that plea to that charge?
What? Can you say that again?
Yeah, do you believe it's in your best interest to enter the plea of no contest to this charge today?
Yes.
Okay. Did you have an opportunity to review one of these plea forms?
Yes, sir.
And do you feel like you understand what you read on it?
Yes, sir.
Do you have any questions about it?
No, sir.
All right. I'll find your plea as free and voluntary. I'll accept your plea, adjudicate you guilty, sentence you to the 8 days time served that you have. Also order you to pay costs associated with the case, which include court costs and a couple other fees that are associated with it. I'm going to give you a year to either pay that or check in with the clerk's office and make arrangements to take care of those costs, okay?
Okay.
All right. Good luck to you. Good afternoon. What's your name?
Brandy Amos.
Randy Amos, okay. Ms. Amos, you are charged, you're before the court on a charge of battery. Do you understand that?
Yes, sir.
And
From the other thing.
let's see, you've got 32 days, case is in Division 81.
She has David Verrett as her attorney, Your Honor.
Okay. David Barrett. So we got a date on that one?
It's gonna be June 16th at 10 o'clock in courtroom 6B.
So your case is going to be set for a pretrial conference on June 16th at 10 o'clock in courtroom 6B. And you'll want to be speaking to your attorney before that time.
Do I have a bond for the battery?
I don't know. I imagine you do.
Most.
Looks like it's a misdemeanor. Any idea?
Robert, did you have a bond?
I don't see that case. Was it reduced from the felony burglary of an adult?
Yes.
Okay, yeah, I don't have a bond. I don't know what the bond is.
Oh, Your Honor, as a friend of the court, 52630. Originally, it came in as a burglary with assault or battery therein, so she was not entitled to a bond because of the life offense. The state did not move forward on that charge. They only charged her with the battery on this case, so I would ask that you set a bond on the battery, given that the state has reduced the charge from a life offense to a regular battery.
Well, it's a misdemeanor. She's certainly entitled to a bond. Any comments on that, State?
Yes, I was just confirming, it did come in as a burglary with assault battery therein in April, and it has been reduced to a simple misdemeanor battery in the first degree. I would just ask the court that there's no contact with the victim, also no return to the location, and a reasonable bond can be set.
I think a reasonable bond would be $500. So I'll set the bond at $500. You're ordered to have no contact with the victim or victims. You're to maintain a separate residence from the victim or victims. You're not to return to the scene of the alleged offense. You're to consume no alcohol, no drugs not prescribed for you by your own physician, and you're to have no weapons on or about your person as conditions of release.
Yes, sir.
So yes, ma'am, you do have a bond.
Thank you.
You're welcome. Good luck. Good afternoon, sir. Your name?
Luis Bonilla.
All right, Mr. Bonilla. You're being held on a charge of resisting without violence. Do you understand that charge?
Yes, sir.
All right, Mr. Bonilla, I read your paperwork. I do find probable cause for the charge. I also notice you qualify for the services of the public defender. Would you like me to appoint the public defender for you in this case?
Could I have a moment, Your Honor?
Certainly. Yeah, I have really fond memories of Ms. Taylor. When I was here, I was her judge. And she made it sure that everybody knew that.
Understood.
And that's the way they would refer to me when I'd come in. It's Miss Taylor's judge.
And, Your Honor, the offer to resolve the resisting an officer without violence was an adjudication credit time served, which Mr. Bonilla would like to accept.
All right.
And it's for a plea of no contest.
So, Mr. Bonilla, you're going to enter a plea of no contest to the charge of resisting?
Yes, sir.
And do you believe it's in your best interest to do that?
Yes, sir.
Have a chance to review this plea form, did you?
Yes, sir.
And you feel like you understand what it says?
100%.
All right. I'll find your plea is free and voluntary. Accept your plea of no contest to the charge of resisting without violence. You'll be adjudicated guilty of the charge, sentenced to time served, which is probably, 2 days?
Yes, Your Honor.
And you'll also be ordered to pay court costs and the other attendant costs associated with the plea. And I'll give you 30 days from the date of your release to check in with the clerk's office and make arrangements to take care of that. Good luck, sir.
Thank you.
You're welcome, sir.
If we could just wait 1 second, I think the MIS is at the door. They just text me. So I'm just,
Back here?
yes,
Think they're there?
yes.
I'll just get up and go back and check.
Culprit is behaving. Why you did culprit like that? Why you did culprit like that?
Unless they're invisible, they're not out
They
there.
just texted me and
They
said,
oftentimes are invisible. IT people can disappear standing right in front of you. Don't you love it when IT people come in and show you how to work the machines and stuff, and they do everything themselves and say, okay, you're good, but they don't show you anything?
yes.
They've been doing that to me for years.
They just texted me. I was like, come up the ramp, so we
yeah.
can go ahead.
Okay, let's see.
And, Your Honor, could we reset for tomorrow? There's actually an offer to resolve the case.
Sure. So we'll just reset tomorrow for a possible plea. Refused.
Could we also reset, there's a possible plea?
No, not on a refusal. He refused. This is his one shot. I mean, if you want to waive it for him, maybe you can set it up later, but yeah, he can't play those games and just come up whenever he wants to.
Okay.
So you want to waive it?
Yes, I don't think I have a choice, Your Honor.
So, Mr. Haddon, we're waiving.
Yeah.
Yeah.
Yeah, Mr. Haddon's being held on a trespass and providing false ID charges. Reviewed the affidavit, do find probable cause. His appearance has been waived here today. Bonds are $500 is to count one, $100 is to count two. No return to 3501 Millennia Boulevard as a condition of release. Thank you.
And we're resetting Mr. Culbreth.
Yeah.
Okay.
All right. Good afternoon, sir. What's your name?
Lamar Lewis,
Mr. Lewis. What's the X stand for?
Xavier,
Xavier.
Javier in Spanish.
Kind of thought that might be it. Well, you're being held on a charge of petty theft, sir, and involving $100 or more. What is the cutoff for petty theft to jump from 2 to 1 these days? The money amount.
Over 100?
That it? Okay. This one says $100 or more. So it's charged as a misdemeanor of the first degree. Now, I see you qualify for the services of the public defender, sir. Would you like for me to appoint the public defender for you?
Yes, sir.
Okay, I'll do that at this time. I do find probable cause for the charge. Bond is set at $500 and you're ordered, let me look back here and see where we were at.
Publix, Your Honor.
Yeah, the Publix, you're ordered not to return to the Publix store located at 400 East Central Street as a condition of release. Do you understand?
Yes.
All right. Any questions you have, direct them to your attorney, sir. Good luck.
I don't have a hold. You don't have any holds. You don't have any holds?
Oh,
You're good? That's it?
all right, so just pay the bond? Mm-hmm. All right.
Okay.
Good afternoon, sir. Your name?
Down in Lloyd.
All right, Mr. Lloyd, you're being held on a charge of trespass on property after warning, which is a misdemeanor of the first degree. Do you understand that charge?
I understand what they're saying, but I don't.
Okay. You don't want to talk about the facts of the case. And I don't see an affidavit of insolvency. Are you not interested in having an attorney appointed for you?
Just the street address information, knowing it's not a trespass.
I can't hear you.
Just the street address information, knowing it's not a trespass. It's for the property for like people like me who don't have a home.
Can I have a moment, Your Honor?
I didn't really hear
Can I
what
have
you
a moment,
said.
Your Honor?
kind of show were you there to see?
Your Honor, I'd ask that you appoint us. I have competency concerns.
Yeah. Well, at present, do you have any income source, sir?
Yes, I have income. Yes, I have income.
Where's that come from?
I own JEA. It's my income right here.
He said he owns the jail.
This is me right here.
Oh, yeah, cool. I owned
Yeah.
it once upon a time. You must have bought it from me.
How you own? How I bought it?
All right, well, I'm gonna go ahead and appoint the public defender for you, so you got somebody working for you here. Your bond is $500, and you're ordered not to return to the Christian Service Center at 808 West Central. You go back there, they're gonna arrest you again, you understand? All right, good luck, sir. Good afternoon, sir.
Good afternoon.
Tell me your name.
My name is Daniel LeGren.
NeGray? All right, sir, you're charged with trespass on property after warning. Do you understand what you're charged with?
Yes.
Okay. Looks like you qualify for the public defender. Would you like for me to appoint a public defender for you?
Yes.
All right, I'll do that. And indicate that the bond on that particular charge is $500.
And Your Honor, the offer from the state to resolve the case was an adjudication of guilt, credit time served, and no return to 65 East Central Boulevard. And Mr. Negron would like to accept and enter a plea of no contest to that.
All right. You know, years ago, I tried to convince them to rig up a little pulley system right here where the council could just attach it with a clothespin to the little pulley system and I'd pull it up and
Smart.
it would be fun if it, but of course they wouldn't do that. It was made too much sense. All right, Mr. Negrin, you are entering a plea of no contest to the charge, is that correct?
Yes.
And do you believe it's in your best interest to do that?
Yes, sir.
Have you ever read one of these plea forms?
Nah. What's that?
Do you read, sir?
I can't see.
He can't see what the form is. The form just.
It's the thing you signed a minute ago.
Yes, I just, yes, yes.
Okay, so you feel like you understand what it says?
Yes, it's understood.
All right, any questions about it?
No, Your Honor.
All right, sir, I'm gonna find that your plea is free and voluntary. Accept your plea, you'll be adjudicated guilty of the charge, sentenced to time served. You are gonna be ordered not to return to 65 East Central Boulevard as a condition of your release. Do you understand?
Yes, Your Honor.
All right, well, good luck to you, sir.
This way?
And your name, sir?
William Sylvester?
Mr. Sylvester. You're charged with battery, sir. Do you understand that charge?
He's talking. Yeah, you've been charged with battery. No. You slapped somebody. He's asking you, do you know what battery is? Battery.
I understand that charge.
All right. And according to the affidavit that you filled out for the public defender, you do qualify for the public defender. Would you like for me to appoint the public defender for you? Sir?
Yes.
Yes? Okay, I'll go ahead and appoint the public defender for you. Now, your bond is going to be $500. You're going to be ordered to have no contact with the victim as a condition
An inmate.
of your release. You seem confused.
Yeah, I really am. I don't even know what the charge.
Well, if you have any questions, won't you direct them to your attorney, and we'll see if we can get them answered that way.
That's for later. Just asking if you understand.
Yeah,
He understands, Your Honor.
All right, so good luck to you, sir.
And it was 500, Your Honor?
Yeah,
Okay, thank you.
and no contact for the victim.
Yes.
Good afternoon, sir. What's your name?
Ryan Peterson.
Ryan Peterson. Mr. Peterson,
PC challenge, Your Honor.
It's the ordinance.
Defense would argue no probable cause to the disorderly. In order to have a disorderly, the affidavit must state that the vehicle stopped was at a traffic light, traffic control device, and based on this affidavit, it does not state that, Your Honor. So I'd argue no PC as to the disorderly.
what says the state?
I just need to pull up the city ordinance. I don't know it.
While we're waiting on that, he's also out on bond on a possession of cocaine charge. That case is assigned in Division 17. Court take no action on that.
Thank you.
I think it's under subsection K, which they were stating that any person who distributes any material to or receives any object from an occupant of a motor vehicle that is stopped on a public roadway in obedience to a traffic control signal, stop, or any other traffic control device. I would just argue that in the affidavit, it says that the defendant was standing at the I-4 westbound off-ramp at Colonial Drive, which at that point would be a public roadway that would be in obedience to a traffic signal.
Your Honor, again, defense would argue that based on this affidavit, there's no indication that the vehicle was stopped at a traffic control, which must be in the affidavit in order to charge him with the disorderly conduct. It does not state it was a traffic control device that the vehicle was stopped at. He could have been stopped at a yield sign. We don't know. There was no indication where this vehicle was stopped.
Well, a yield sign is a traffic control device.
Yes, but there is nothing in here to state. It
I
doesn't
agree,
state.
it's not in there. So affidavit appears to be insufficient for the court to find probable cause. That being the case, one of two things can happen. I can ROR him today on the charge, or state, you obviously have the right to ask for a 24-hour extension to juice up the affidavit.
I'll give a 24-hour extension, just email the officer and see what he says. I will ask for a 24-hour extension. We could reset it for tomorrow, Your Honor.
Okay.
And
Well, in the meantime, he has a bond. I'll grant the 24-hour extension. He has a bond of $250, so if he can post that, he's still free to go, but otherwise, we'll see him back tomorrow. And no action on the case he's out on bond on.
Okay, Your Honor.
The door? Oh, you were pointing to the door? Oh,
Thank you. The MIS is at the door.
Let's see, step right up there, sir. Good afternoon, sir. What's your name?
Frederick Wentz.
All right, Mr. Wentz. I seem to remember you from a long time ago when I was down here.
Yes, Your Honor.
Been around for a while.
Hey, we're getting older.
Well, we're all getting older, but, you know, we don't talk about that.
Yes, sir.
So the charge, Mr. Wentz, is camping. You understand that? City ordinance. And you do qualify for the public defender. Would you like for me to appoint the public defender for you?
Yes, sir.
I'll do that. Appoint the public defender. That being the case, counsel, can we resolve this one?
yes, the offer from the state was an adjudication of guilt, credit, time served, and court costs. Was it no? Did you ask for a no return?
Just no return to the local.
And Mr. Wentz would like to accept the state's offer and enter plea of no contest. Your Honor, do you have the case number?
Yes, ma'am, it's 23MO736.
Thank you.
This particular city ordinance, if you think about it, sort of logically, but sort of in a practical way, that if you went down to Lake Eola and threw a blanket on the ground and laid down to just sort of sun yourself or, something like, in fact, I had a case like this out here one time where the person was a resident right around the park somewhere and was over there and just threw a blanket down. And actually, there were two people, a male and a female, and they were just sort of taking it easy in the park and they fell asleep. And guess what?
Arrested.
They got arrested and charged with camping.
Mm-hmm.
And I said, well, that statute, that ordinance needs to be rewritten to make it clear that that wouldn't be an offense, but.
Yes.
So, Mr. Wentz, you've read these plea forms before, haven't you?
I believe so, Your Honor.
Yeah. And when you read them, did you feel like you understood what you read in them?
Yes, sir.
Okay. So you're entering the plea of no contest to the camping charge, is that correct?
That's correct.
All right. And finding probable cause, I'll accept your plea of no contest. You'll be adjudicated guilty, sentenced to time served, ordered to pay court costs and the other attendant fees with the charge and the plea. And I'll give you 30 days to check in with the clerk on that and work something out, okay?
Okay.
Good luck.
All right. Thank you, Judge.
You're welcome, sir.
Your Honor, may I open the door for them now?
Are they out there?
Yes, sir.
Are you sure?
That's what
You gonna
they,
pay me $5 if they're not out there?
I will make them pay you
Get that
$5.
$5 out.
They will pay you $5 of their money.
Hey, Robin, this guy, do you have a third? I don't know why I see. I mean, 4? You don't have 4? Okay, I'm just making sure.
He was released on his own recognizance for,
Oh, on one.
case, another failure to appear.
Okay,
So now we just have,
okay. But the 2 that he's here for 2 no valids? I know, but 2 of them are no valids?
attach and tag, no motor vehicle registration, no valid.
Okay, got it. Drop the fees for the second no valid.
Oh, I serve many, many purposes in my role as judge.
Thank you.
Including the main door opener. All right, good afternoon, sir. What's your name?
Donald Frank.
Donald Frank. All right, Mr. Frank, you're being held on a failure to appear capious that was issued in Division 81 on operating a motor vehicle without a valid driver's license. It says you failed to appear on, well, some point.
Yes, Your Honor. In all of the 3 failures to appear that he's here today, 2021 CT 3978E, 2021 CT 2342AO, and 2021 CT 2341AO. The offer from the state was a withhold of adjudication, credit time served, as well as court costs, Your Honor.
So it's a withhold as to each of the 3 counts, one set of court costs, and whatever other fees are associated with, is that correct?
Yes, Your Honor.
Okay. Mr. Frank, did you have an opportunity to read this plea form?
No.
Have you ever read one?
No.
You have anybody read it to you?
Yeah, I have.
We went over it in
We
the,
went over it.
Okay. So you understand these are rights that you're giving up by entering a plea of no contest to each of the 3 charges? And do you believe it's in your best interest to enter the plea of no contest today?
you gotta say it out loud.
No, yes.
All right.
Yes, Your Honor.
Well, then as to each of the 3 counts, I'll accept your plea of no contest, withhold adjudication of guilt. I'm going to impose 1 set of court costs and also the attendant fees that are associated with the plea. Give you 30 days from the date of your release to check in with the clerk and make arrangements to get that paid.
Thank you so much.
You're welcome, sir. Good luck.
Those cases are closed, you just have 1 no valid that you gotta deal with. There's a on this court.
Your Honor, Stokes was
All right.
released PTR.
That's it.
Pardon me?
Stokes. John Stokes.
Stolt?
No, I don't have that person.
I saw that name somewhere. Okay. Yeah, I don't have the file anymore, so somebody done relieved me of that. All right.
I mean, the last person, did he have 3 cases or 4 cases?
He was ROR'd on the 4th. That's why it didn't show up. Because I have 4 as well.
It should just be 3.
One of the no valids, I believe, was ROR'd.
All right, Stokes. All right, hello, what's your name?
Tequila Baker.
Ms. Baker, you're being held on several charges. Let's see, looks like trafficking in methamphetamine is count 1, trafficking in cocaine is count 2, possession of drug paraphernalia count 3, and possession of narcotics with intent to sell or delivery is count 4. Now, do you understand what you're charged with?
Yes.
Okay. I'm looking at your affidavit. You do qualify for the public defender. Would you like for me to appoint the public defender to represent you?
Yes.
All right, I'll do that at this time. And having read the affidavit, I do find probable cause for the charges. Your bond is to count 1, I'm going to stay at $50,000. As to count 2, it'll be $150. Count 3, $100. Count 4, $150. Understand? Now, any questions you have, you want to direct them to your attorney. All right, good luck.
It's 10% with the bail bond.
Good afternoon, your name?
Amanda Barrett.
Ms. Barrett? You're being held on, what do we got here? An arrest warrant, charging you with burglary with an assault or battery, felony battery, and battery. So 3 different forms of battery. The burglary with an assault or battery therein is what's called a punishable by life felony. So therefore, you're being held no bond on that one. As to the felony battery, the bond per the warrant is set at $5,000. As to the battery itself, the bond is set at $1,000. Now, I see you qualify for the public defender. So would you like for me to appoint the public defender to represent you?
Yes, please.
All right, I will appoint the public defender to represent you. And
Your Honor,
I'm going to add some conditions.
Your Honor, you do have the discretion to set bond, given she has no criminal history other than a petty theft from 2016. She's been in the area for over a year. She resides in Windermere. She's a student. I would ask that you consider setting a bond in this case, as opposed to holding her at no bond.
What says the state?
I have to pull up the arrest affidavit, Your Honor. Give me 1 second. I'm trying to pull up the document. Come up. When I click on this, it's not coming. But it's not coming up. Still waiting.
While we're waiting on that, what is the Wolfgang Academy?
Dog grooming school. I have a farm with golden doodles.
I didn't hear you.
That's what I've been.
Dog grooming. I have a golden doodle farm. I breed them.
Dog Grooming Academy, here locally?
Yes.
Oh,
Off Colonial Drive.
where at on Colonial?
Across from the Oak Square Mall. In the plaza.
Okay,
Yes, sir.
dog grooming. That's funny, I think my wife is at the dog groomer today with her dog,
Oh, nice.
a standard poodle,
Oh, yeah, I love them, yeah.
wacky dogs.
Golden doodles. Poodle and a golden retriever mix. Yeah, they're beautiful.
They're really trippy dogs. My wife said she was gonna get that standard poodle. I said, no, we can't have no foo-foo dogs. It's not a foo-foo dog. That thing weighs 65 pounds.
Password? I don't know why.
No, I sold them for cheaper, but they're sweet.
I have a relative that has a mobile dog grooming business
That's nice.
out in Arkansas.
Oh, nice.
And she loves it. She used to be a producer at a TV station, and she gave it up to go into the mobile dog grooming business.
It's fun if you love it, yeah.
Yeah, I would imagine with some of them, but some of the dogs I would imagine are a bit difficult to deal with.
Yeah, there's a bunch of difficult ones. I deal with the difficult ones because somebody wants to, so I
Yep.
just have to patiently wait with them.
I shall tell you, if you don't trim one of those poodles, they look like a big fluff ball after a couple of weeks.
Oh, yeah, they do.
Brenda and them are here most of the time.
So state, we're gonna have to move
Yes,
on.
we can issue a reasonable bond, Your Honor. I just read it, I'm sorry.
Okay. Let's see, we got 5,000 on count 2, 1,000 on count 3, so I'll set your bond on count 1 at $150.
Oh, thank you. Thank you, sir.
Good luck. Yeah, no contact with the victims, be good, don't.
Good. No return to the location, Your Honor.
Breed some dog.
Yeah.
There was also no return to the
Yeah,
location.
no return to the
Yes.
location. And then never forget, be good. All right, your name, please.
Say your name.
Jackie Bridges.
All right, Mr. Bridges, you are charged with possession of cocaine and possession of ammunition by a convicted felon. Both actually are felony counts. You understand what you're charged with?
Yes, sir.
All right, well, I did read the affidavit. I do find probable cause.
Your
I
Honor,
don't see an affidavit of insolvency, though. You gonna talk to a private attorney, or
he filled one out, Your Honor.
did he? Take a peek at it and tell me, how's it look?
Let's see. It says he has no income and no dependents.
Okay. I'll appoint the public defender for you for today's purposes only. And then you, once we get the affidavit and determine that you qualify, we'll consider making it permanent. Now, your bonds, and I'm assuming this is because you're from out of state, Childersburg, Alabama.
Your Honor, he qualifies for pretrial release.
Yeah, he does. Really? Being from out of state?
It's in the pop.
Huh?
It's in the pop.
See, I've got a Childersburg, Alabama,
That's where his,
Your Honor, he'll sign here.
he's gonna be staying with his grandmother.
but y'all confirmed Apopka?
Yes, he
Okay.
lives here with his grandmother.
Yeah, he qualifies for PTR, so I'll go ahead and authorize his release PTR.
And I just asked that you appoint us permanently, Your Honor. He just signed the form. I just copied what was
All
already
right,
written.
we'll make the appointment permanent.
Thank you.
He will be your client for the rest of your career,
Thank you.
no matter where you go.
Are we doing PTR, Your Honor, on both?
I don't know what conditions I'd put on that anyway. Don't do cocaine.
Your Honor,
about
excuse
that?
me, is it PTR on both charges?
PTR on both.
Was there conditions?
Yeah, don't do cocaine. That's a good condition, don't you think? Think he'll comply with that? I don't know if he will. I can never tell.
But they're handing him in, they're saying, I don't know. I really don't.
Kind of like telling your kids, don't get in a cookie jar. So your name, sir?
Lamont Brisbane.
All right, Mr. Brisbane, you are being held on a charge of possession of MDMA.
Yeah, stop.
Do you understand that charge?
Yes, sir. It stopped me from moving.
And there's more, I think. Nope, that's somebody else. All right, and you do qualify for the public defender, sir. Would you like to have the public defender appointed to represent you?
Yes, sir.
All right. I'll appoint the public defender, indicate that I do find probable cause on the possession of MDMA charge. Bond will be stated $1,000, and no action on the case you're out on bond on.
Your Honor, Brown Shaquille bonded.
Okay, Brown Shaquille bonded. There we go. Thank you, sir. And your name, sir?
Say your name.
Cardona. Kenneth Marrero Cardona.
Okay, Mr. Cardona, let's see what we got here. Possession of cocaine is a charge, sir. And looks like you qualify for the public defender. Would you like for me to appoint the PD for you?
Yes, sir.
All right, I'll do that at this time. I do find probable cause on the possession charge. And the bond on that is $1,000. You're out on bond on a battery case. That's assigned in Division 10, so the court will take no action on that.
Thank you, Your Honor. Have a good day.
You're welcome. You have a good day, too. And your name, sir?
Arnold Coleman.
All right, Mr. Coleman, you are charged with possession of MDMA, also known as ecstasy. And it looks like you qualify for the public defender, sir. Would you like for me to appoint the PD for you?
Yes, sir. Yes, Your Honor.
Okay, I'll appoint the PD for you for this case. Indicate that I do find probable cause on the charge. And stay your bond at $1,000. Good luck.
Thank you.
Ooh, I can sign those. Where'd those come from? Yeah, today? Is that today's stuff? Yeah, I sign it anyway, but might as well ask. Let's see, your name, sir?
Sir.
Michael Coleman?
Sir.
All right, Mr. Coleman, you're charged with grand theft of a motor vehicle. And let's see, does look like you qualify for the public defender. Would you like for me to appoint the public defender for you?
Yes, sir.
All right, sir, I'll do that. Do find probable cause on the grand theft charge, motor vehicle. Bond is stated $1,000. And good luck to you. You're welcome.
Your Honor, I'll also just ask to no return to the location. No contact with the victim.
7245 Willowwood Street. Yeah, no return to 7245 Willowwood Street. All right, good afternoon. Your name?
Good afternoon, sir. Quintavious Diaz.
All right, Mr. Diaz. You are charged with possession of cocaine and resisting without violence. That cocaine charge is a felony. The resisting is a misdemeanor.
Sir.
Now, you do qualify for the public defender. Do you understand that?
Yes, sir.
Would you like for me to appoint the public defender to represent you?
Please, sir.
All right, sir. I will at this time appoint the office of the public defender to represent you in the case. indicate that I do find probable cause as to the affidavit. As to the cocaine charge, the bond will be stated at $1,000. The resisting charge bond will be set at $100. Good luck, sir.
Thank you, sir.
You're welcome, sir.
No action, Your Honor? I'm sorry.
Oh, he's out on bond. Yeah, no action on the out on bond.
And the keyboard's wireless.
T-O-T. You mean they came and got him already?
Wait, last name is Andre?
That was efficient.
Last name Dimi, D-I-M-I-A-N.
I don't have that person.
First name Andre.
All right, next up. Let's see, your name, sir.
John Elbert Duncan Jr.
All right, Mr. Duncan, you're charged with several felony charges in 2023 CF 6829. Aggravated assault with a deadly weapon, aggravated assault, 2 counts aggravated assault with a deadly weapon, 1 count possession of a weapon by a convicted felon, actually there's 2 counts of that. Armed trespass and robbery with a deadly weapon. Do you understand those charges?
Yes.
All right, you also had an outstanding warrant on a, what is this? Trespass on property other than a structure conveyance. That warrant sets a bond at $250. Now, you do qualify for the public defender, sir. Would you like for me to appoint a public defender for you?
Yes.
All right. Then, finding that you qualify, I'll appoint the public defender's office to represent you. So let's talk bonds. They got no bond on everything here. You looked this one over, State?
I did.
Actually, the robbery with a deadly weapon, that's a PBL, right?
It is, I looked at the affidavit and I would say the court could set a reasonable bond, but there's no return to the location.
So that
Also, no
includes on the
contact with the
PBL?
I would say all the charges, a reasonable bond to be set.
Okay, all right.
No contact with the victim, no return to the Christian Center,
Yep,
which is on Central Boulevard.
got it. Okay, so $250 on the warrant is the bond. As to the aggravated assault with a deadly weapon, that really probably not a PBL. Set the bond on that one at $15,000, sir. That's to count 1. And then $150 as to 2, 3, 4, and 5. And then robbery with a deadly weapon will be an additional bond of $25,000. You're not to return to 808 West Central, which is the Christian Center. You're to have no contact with the victim or victims. As a condition of your release, you're to have no weapons on or about your person as a condition of release. And just for giggles, we'll throw in no alcohol, no drugs to be consumed by you unless the drugs are prescribed for you by a physician. Good luck, sir. All right. Oh, that's Kelvin. Okay. All right. Your name, sir?
Ryan Alberto Garcia Rivera.
Garcia Rivera?
Sir.
Is that correct? Okay. Let's see, you're charged with unlawful use of a two-way communications device. That is via warrant signed by Judge Dean. Bond on that is $1,000. Judge Dean found probable cause on that. And let's see, Kelvin Melendez, that's, yeah. And you do qualify for the public defender, sir. Would you like for me to appoint the public defender for you?
Yes.
All right, this time the court will appoint the public defender for you. Stay the bond in the amount of $1,000.
That's it.
Your Honor, Haywood Fred,
You're not here for that. Defense will waive, Your Honor.
Yeah, just throw that in there.
Already been seen on that, no?
Okay, so Mr. Haywood
No?
declined to attend, huh?
Yes, Your Honor, hold on.
Did you want to waive on Haywood?
I did, Your Honor, yes, I would. like to
Okay.
waive.
And let's see what he's got. He's out on a petty theft with 2 prior convictions. This is a burglary of an occupied dwelling and larceny. So I'll stay his bonds at $5,000 as to count 1, $250 as to count 2. Go ahead and appoint the public defender to represent him and indicate that I do find probable cause on both charges.
It looks like they revoked all your.
Are you taking any?
Yeah, no action on what he's out on bond.
Up a new charge. I'm assuming for.
Yeah, we'll just
Oh,
appoint him.
okay.
Oh, that's why. So you got.
Save us the trouble of doing that further down the road.
new-
All right, good afternoon, sir. Your name?
Khalil Hedrington, Your Honor.
Could you say that a little louder?
Khalil Hedrington, Your Honor.
All right. Mr. Harrington, you are being held on a failure to register charge. And that's pursuant to a warrant. Yeah. Wherein the judge who signed the warrant found probable cause. Set your bond at $1,500, and you're ordered to report to register within 24 hours of your release. Now, do you know who you got to register with?
The Sheriff's Office, Your Honor.
Yeah. So that's got to be done within 24 hours of your release. Failure to do that, I'll see you again.
Yes, Your Honor.
All right, good luck.
Thank you.
And your name, sir?
Nikhil Jean-Francois.
All right, Mr. Francois, you're charged with carrying a concealed firearm in grand theft third degree. Do you understand those charges?
Yes, sir.
All right, sir, I did read the affidavit. I do find probable cause for the charges. Looks like you qualify for the public defender. Would you like for me to appoint them to represent you?
Wait, this one gonna represent me?
Maybe not her personally, but somebody from the public defender's office?
But somebody from the office. Someone else.
So do you want them or not?
I don't know. I don't know if it's not, cause she look like she do a good job. I mean, wait, what's her name?
Well, I think I'm probably happy I didn't understand what you
Letitia
said.
do a good job, so I don't know. If it's not Letitia, I probably get my own lawyer.
You want to get your own lawyer?
If it's not Letitia.
Me, I'm sorry.
Well, I can't guarantee you that you'll get anyone in particular from the public defender's office, so is it going to be a private lawyer or a public defender?
All right, look, we're gonna do public defender for now, then I get my lawyer. All right, yeah, public defender, public defender.
This is all a big joke to you, isn't it?
No, it's not.
It's all right to have a sense of humor.
It's not a joke.
Got one myself. But this is serious stuff you're looking at. But you don't seem to take it seriously, but that's okay. You can do what you want. So you do qualify, so I'll go ahead and appoint the public defender for you. And then if you decide to hire a private attorney will know what to do from there, okay?
Mhm.
Good luck.
And the bond
What was
remains.
the bond, Your Honor?
What was the bond? Oh, it's 2,500 is to count one. It'll be,
Wait, yeah.
150 is to count two.
No, it'll clear. So
Oh,
just
so
have them
I could just, they already paid it, so I could just go home?
I don't think it cleared yet. The bond didn't post, right? No.
Oh, it ain't cleared yet? Oh, okay.
It never went through.
Okay.
So now it can.
Oh, okay. All right. Thank you. Have a good day.
You too.
And look, I'm happy because I'm good.
Okay, good. I'm glad. I really am. It's nice to see somebody come through that's in a good mood for a change. Let's see, your name, sir?
Morris Johnson.
Lawrence Johnson. Mr. Johnson, you're being held on a violation of a condition of pretrial release.
Yes, sir.
I'll tell you what that condition was, if you give me a minute. Says you, you failed to show up, to check in with pretrial release. So you got a warrant, and unfortunately for you, the warrant directs that you be held no bond pending further order of the court. So, Mr. Johnson, now you do qualify for the public defender. Would you like for me to appoint the public defender for you?
Yeah.
All right, well, I'll appoint the public defender to represent you.
So I
And the
don't
court will
get
stay your status at no bond.
Attorney has. The judge.
Good afternoon, what's your name?
Mary Luz Losama.
All right, ma'am, you are charged with armed trespass in a structure. That's pursuant to a warrant that was issued wherein the court that signed the warrant found probable cause for that. I'll stay your bond pursuant to the warrant at $1,000. Now, you do qualify for the public defender. Would you like for me to appoint the public defender for you?
Yes, sir.
All right, I'll appoint the public defender for you, and stay in the bond at $1,000. No return to the scene of the offense, no contact with any victim or victims, no weapons on or about your person, and I'll take no action on the case you're out on bond on.
All right. But they had checked my bag. I didn't-
How much, it was, 1,000, Your Honor, right?
Yes.
Okay, thank you. So let them choose you know that. I'm not sure.
Oh. Okay.
Another happy customer. Got a lot of good moods today. Must be the weather, huh? Sir, what's your name?
My name's Maxie.
All right, Mr. Maxey, you are charged with burglary of a conveyance and petty theft. Do you understand those charges? Well, sir, I reviewed the affidavit in your case. I do find probable cause for the charges. Bonds will be stayed at $3,500 as to count one, $100 as to count two. I also noticed that you qualify for the services of the public defender. Would you like for me to appoint the public defender for you?
Sir.
All right, this time the court will appoint the public defender to represent you in the cases. No action on the case. He's out on bond. Good afternoon, your name?
Sophia McCord.
Ms. McCord, you are charged with battery on a law enforcement officer. Do you understand the charge?
Yes, sir.
You do qualify for the public defender. Would you like to have the PD appointed to represent you?
Yes, sir.
All right, I'll do that at this time. I did review your affidavit. I do find probable cause for the charge. Bond is going to be stayed at $2,500, ma'am. Good luck.
Thank you.
You're welcome. Afternoon, sir. Your name?
Quinones.
Elliot Quinones. All right, Mr. Quinones, you are charged with trafficking in fentanyl, possession of fentanyl with intent to sell or deliver, and possession of a firearm in the commission of a felony. Do you understand those charges?
Yes.
All right. Now, I see you qualify for the public defender. Would you like to have the public defender appointed to represent you?
Yes.
All right, sir, I'll appoint the public defender to represent you at this time. I do find probable cause on the charges. Bond as to the count one is, by the bond schedule, is $100,000. $150 each as to counts 2, 3, and 4. And I think it would be a good idea if you did not return to the scene, which is 2527 West Oak Ridge Road. as a condition of release. No action on the case you're out on bond on.
Your Honor, Ramos?
Yes.
Refuse?
Defense will waive, Your Honor.
Okay, well, I appreciate that. Let's see, Mr. Ramos is charged with trafficking in fentanyl, possession of a firearm by a convicted felon, possession of ammunition by a convicted felon, possession of fentanyl with intent to sell or deliver, possession of fentanyl simple, possession of firearm in the commission of a felony, and possession of cocaine with intent to sell or deliver. Now, this was an interesting affidavit to read. Having read it, I do find probable cause for the charges. Bonds are $100,000 as to count one, $150 each as to counts 2, 3, 4, 5, 6, and 7. And then separate and apart from that, he has a, this is in 2023 CF 3880. Possession of MDMA, that's pursuant to a warrant, which sets his bond at $1,000. Probable cause was found by that court. And I'm going to go ahead and appoint the public defender for him.
Thank you, Your Honor.
Inside, he's not up here. And that'll do it. Good luck. Good afternoon, sir. Your name?
John Randall.
Mr. Randall, you're being held for a failure to appear in Division 11. Says you failed to appear for a case management conference. Let's see, I don't see the date on there, but
May 4th.
yep, May 4th, there it is. And that court issued a capias and ordered you held no bond, sir. Did you have an attorney in that case, sir?
He has the PD's office,
Yes,
Your Honor.
okay. Well, that's your best friend. So if you have any questions, you direct them to your attorney, sir.
It's the same case, Mr. Randall. They dropped one charge, but they kept the second open. They did a notice of non-filing for 33 days. You were released, but then later they filed the information. You're gonna have to go over and speak.
Letitia, they did make an offer to him. They did have an offer, but he didn't appear.
Yes, I know. You have to do it.
All right. Yes, sir. Step up there. Tell me your name.
Joseph Lloyd Renford Jr.
All right, Mr. Renford, you are being held on a charge of armed trespass in a structure. That's pursuant to a warrant. The judge who signed the warrant found probable cause on that. Set your bond at $1,000 and then, and no return as a condition of release. And then you also have a separate charge in Division 80, trespass on property after warning. That I found probable cause for after reading the affidavit. Bond on that is set at $500. And it looks like you qualify for the public defender on both counts. Would you like for me to appoint the PD for you?
Yes, sir.
All right, I'll appoint the PD for you on both. And no action on the case, he's out on bond.
Okay, thank you.
Afternoon, sir, your name?
Corey Roberts.
All right, Mr. Roberts. Pursuant to a warrant, you are being held on a charge of burglary of an occupied structure. And that warrant, signed by Judge Carestes, found probable cause for that charge and sets your bond at $3,500. I'm going to order that you not return to the scene of the offense as an additional condition, no contact with any victim or state witnesses. And then you have a separate burglary of an occupied structure and petty theft. Let me check my case numbers here. Yep. That also is pursuant to a warrant, setting a bond at $2,500 on count 1. 1,000 is to count 2. Also ordered not to return to the scene of the offense. No contact with the victim as a condition of release. Now, you do qualify for the public defender, sir. Would you like to have them appointed?
What was that, sir?
You qualify for the services of the public defender. Would you like to have me appoint them for you?
Sir.
All right, this time the court will appoint the public defender to represent you. Good luck.
So that's what that is.
Let's see, good afternoon. Your name, sir?
My name is Tasman Robinson, sir. Tasman Lamar Robinson.
Mr. Robinson, you're being held on a capias that was issued alleging a violation of community control.
Yes, sir.
The violation alleges failed to submit to electronic monitoring, indicates you removed the device and left home without the device on you.
Yes,
That court has ordered that you be held no bond on the violation. And did you have an attorney in that case? Sir?
Sir?
Did you have an attorney in that case?
Yeah, I had a attorney on, I think it's, I forgot the name is, yeah, I had an attorney. I forgot the name, though.
Was it a public defender?
Yes, sir.
Okay, well, I'll go ahead and reappoint the public defender for you in this case, all right?
Yes, sir.
He does have reporting requirements.
And you got reporting requirements, you know that? You got to report where you're living to the sheriff's department and all that sort of stuff?
Yes, sir.
Okay, make sure you report.
But I ain't
You got
out.
this, you got to report this arrest as a change of address.
Yes, sir.
It's just as if you had moved.
Yes, sir.
So within 24 hours of your release, you got to get to the sheriff's department, report this arrest.
Oh, you know, you was telling that boy to get out today.
Your Honor, did you give a bond on this?
Pretty sure.
I gotta go back to work and everything, man.
No, it's no bond
That's all right.
pursuant to the warrant.
Thank you.
You're welcome, sir. Good afternoon. What's your name?
Xavier Sanchez, sir.
Mr. Sanchez, you're being held on some failures to appear in Division 10. And a capias was issued that was on a possession of a firearm by a convicted felon, possession of ammunition by a convicted felon, trafficking in 10 grams or more of, I can't pronounce that. Anybody want to give that a shot?
Fentanyl.
Whatever that is.
Fentanyl.
Anyway, the court that issued the capias ordered you held no bond on all the charges.
Yes, sir.
Now, did you have an attorney in that case?
I did. I don't recall his name, though.
Was it public defender?
Your Honor.
Okay, I'll reappoint the public defender for you.
Thank you, sir.
Good luck. Afternoon, sir. What's your name?
Sean Smith.
George Edward Shot?
Yeah, I was shot. I was at my hospital bed. I'm trying to be R&R today.
You're Mr. Shot, right?
I'm the one that was shot. No, I'm
Oh, he said your last name.
What's your name?
Smith. Smith.
Your Honor, my apologies. Mr. Shot bonded.
Okay. So what is your name, sir?
Sean Smith. What's your name,
Sean
sir?
Smith. How about Mark Lewis Segreto?
Ready is on mental health status, Your Honor.
All right, mental health, so I guess reset.
You know, reset or wait?
Waive, Your Honor.
All right. Thank you for that. What do we got? Petty theft, 2 or more priors pursuant to a warrant, probable cause found there. Bond is $2,500 and no return to the scene of the alleged offense. That's on Segreto. All right. So, Mr. Smith, okay, in Division 17, you're charged with burglary of an occupied dwelling unarmed. And, oh, yes, I do recall this. Yeah, I looked at the affidavit. I do find probable cause on the charge. Looks like you qualify for the public defender, Mr. Smith. Would you like for me to appoint the public defender for you? Yes?
I understand.
Yes or no?
Oh, yeah, she's gonna defend me. If not, I can defend myself.
Yes or no on the
Oh, she was
appointment?
asking if you want a public defender.
Do I want a public defender?
Yep.
I
Okay,
want to
I'll
be
appoint
R&R. Yes,
PD.
sir. R&R me. R&R me.
Yep, I'll appoint the PD for you. Bond is $5,000.
Yes, I don't need an attorney because I.
Hey, Mr. Smith,
Okay, you don't need.
Yes.
your best bet is to listen to what I'm saying.
Yes.
Bond is $5,000. You are not to return to 2125 Laurel Blossom Circle. You're to have no contact with the victim or victims. So make it real clear, you're not being ROR'd today
Why?
because the charges are sufficient that ROR would be ridiculous.
I just need your help that in R&R me because I have an address where I've mailed there. I've stayed in my mother's there. I've been shot in my knee. Sir, they're not listening.
I think I did.
What's his name? And you fired. I don't need you.
No, I think I did.
I'm fired.
At least it was my intent. So you can imply that I appointed the public defender.
I'm fired today.
All right, let's see. What's your name, sir?
Juan Valdez.
Does that ring any bells? Juan Valdez?
It's Valdez Castillo.
It was the commercial. Do you remember that commercial?
The coffee.
Coffee commercial. Yeah. It reminded me, I'd like some coffee right
They
now.
always call me the coffee guy in school.
That's funny.
No offense intended, friend.
Okay.
It's, you know, if you do this day in and day out, occasionally you just gotta inject a little bit of humor.
Mm-hmm.
And some days it works, some days it fails miserably. Believe me, I've had the booing crowd before. So, Mr. Valdez Castillo, you got a failure to appear in Division 23. A capias was issued. That was on May the 4th for possession of
It's okay.
UD loan? What the heck is that?
Utilized.
Possession of drug paraphernalia. And that court in Division 23 was disturbed and upset and otherwise not happy. And so they ordered that you be held no bond on that.
Your Honor, we are already appointed.
Yeah. So you're already in his case? Okay.
Set a bond.
And then there's a, see, that was 689, then in 2021 CF 9360, also a failure to appear. Also in Division 23, also for a competency hearing, and the order is no bond.
Is there any way I could be sentenced to a rehab? Because I would really like to do rehab.
What would you like to do?
Rehabilitation, maybe with Aspire or
If you take your mouth just a little bit away from that microphone.
Asking for, to be sentenced to Aspire. Your
to a
Honor.
rehab, to a rehabilitation.
You know, that might be a perfect solution for you, but this is not a sentencing hearing. This is just an initial appearance.
Okay, I
Under
would like to-
Florida law, it's required that you be brought before the court within 24 hours of your incarceration to make sure that you understand why you're being incarcerated.
Oh, okay.
And to address any other issues that might arise, but jurisdiction does not exist here to sentence you to anything,
Oh, okay.
okay? So good luck.
Thank you.
You're welcome. If I didn't say it, I meant to appoint the PD in that case. He definitely needs them.
Mm-hmm.
So what else we got?
I know. That's it.
That's it for the day? Time for possession of methamphetamine, possession of drug paraphernalia, and petty theft of $100 or more. You understand those charges?
Yes.
I reviewed your affidavit. I do find probable cause for the charges, sir. Now, can you afford an attorney?
No, I can't.
I don't have an affidavit of insolvency, so I can't see if you qualify for the long term for the public defender, but what I'll do is appoint the public defender temporarily for today's purposes. Do you understand that?
Yes.
Okay. Now, having found probable cause for the charges, your bond on the possession of methamphetamine is $1,000. The possession of drug paraphernalia will be $100, and the petty theft charge will be $100. You're also going to be ordered not to return to the Walmart at 5734 South Orange Blossom Trail. Do you understand that?
Yes.
Okay. Now, if you have any questions, you're going to want to direct them to your attorney. Do you understand?
Yes.
All right?
Your Honor,
Yeah.
I'm sorry, I'm just looking at his history. He does, let's see, has some out-of-state history, nothing really violent. He has no convictions here in Florida. I'm willing to do straight pretrial release. We were unable, we have 2 notes where we were unable to verify his community ties, but then it was also noted that his address was verified through emergency contact.
So you're comfortable with PTR
Yes.
straight down the board?
Yeah.
Okay.
I'm comfortable with PTR.
State, care to be heard on that?
I will just say, Your Honor, that says that he's only been in Orlando for 3 months to a year possibly, which shows that he does not have a lot of ties to Orlando. He does have 3 or more out-of-state felony convictions. So at this time, I'm more comfortable with a bond.
Your Honor, given that he does qualify for pretrial release, he's currently on Social Security disability. Pretrial release would actually monitor him. So if the state's concerned about any further altercations or the lack of community ties, pretrial release would be able to actually monitor him versus posting a monetary bond where he would have no type of supervision. I think that pretrial release would be sufficient in this case. No failures to appear, other than he has an out-of-state conviction, but he doesn't have anything other than that.
Okay. You understand that pretrial release is a monitored type of release, sir?
Okay. Yes.
Where you have to check in with pretrial release and they sort of monitor where you're at and what you're doing, that sort of thing, make sure that you understand when you got to go to court and that sort of thing?
Will I be like on a house arrest? Will I be on echo?
No, it's not house arrest. That's a totally different thing. This is monitoring you from afar.
Okay.
And then if you don't comply with the rules of pretrial release, you could be rearrested and brought back here for the court to determine what other conditions of release you might be out under.
Okay.
Okay. So, yeah, if you qualify for PTR is comfortable with your, who you are and your situation, I'll go ahead and authorize pretrial release as to the 3 charges.
Any conditions, Your Honor?
Yeah, no alcohol, no drugs, other than drugs prescribed for you by your own physician, and no weapons on or about your person as conditions of PTR. Plus, the conditions PTR is going to put on you. And no return to Walmart. All right?
Okay. Yes, sir.
And Your Honor, as far as the PD is concerned, he's not making any income. I'm gonna have him sign the PD form right now. I would ask that you appoint us permanently, and I will provide the form to the clerk.
Okay. That being the case, I'll appoint the PD straight across the board.
So just give him the clerk.
My cardiologist was telling me yesterday, I was telling him about the snake I had to deal with out at our place. And he was telling me he and his wife saw a rattlesnake go into their garage. And he lives out in Bay Hill somewhere in some big monster mansion. It's probably about an 8-car garage. And he goes in, he looks for it, he can't find it. And I said, so it was a rattlesnake? He goes, oh yeah, it was a rattlesnake. And I said, what did it look like? And he goes, it was bright orange. I said, rattlesnakes are not orange. He goes, oh no, it was rattlesnake. I said, but you didn't see it once you got in the garage. He goes, yeah, but I knew. I said, what you're looking at there, pal, is a corn snake or a rat snake. And I guess he wanted it to be a rattlesnake because he argued about it. I said, you could have gone and picked up the snake and carried it out of your garage. They don't even bite. It was funny, though. Thank you, sir. Good luck. Thank you, counsel. Thank you, state.
I'm sorry, I took your badge.
Step right up there, sir. Good morning.
Morning.
What's your name?
Lord Portier.
Portier.
Yes, sir.
Famous name.
Yes, sir.
Didn't he die recently?
Yes,
He
sir.
did.
Unfortunately.
I thought he did die. Sidney Poitier.
Yes, sir.
Heck of an actor.
Yes.
You have what? Yeah? Got it all? Every bit of it. So, Mr. Portier, you're charged with littering on public property, lakes, and private property. Well, actually on public property, but you understand what you're charged with?
Yes, sir.
All right. And let's see here. Yeah, I don't see an affidavit, but I do have a plea form here.
Sir.
Is it your desire to enter a plea to the charge?
Yes, sir.
Okay. Let's hear what the state would like to see me do before we go forward with that plea, okay?
Yes, sir.
All right. I did read the affidavit, by the way, and do find probable cause for the charge. So, state, what you looking for here?
It's a city ordinance, Your Honor. What would be the time served at this point?
Let's see.
How about no return to Lake Eola for 6 months?
See, today is 2 days.
Yeah, credit for time served, no return. It says Magnolia and Central, so I'm not sure if that's Lake Eola. I was just saying that area.
Yeah.
I'm sorry, it's 3 days, state. 3 days. I'm sorry.
Credit for time served, no return to the area.
All right. Okay, so, Mr. Portier, I've got a plea form here that you signed. Did you read this thing?
Yes, I did.
Did you understand what you read on it?
Sir.
You have any questions about it?
No, sir.
You understand by entering a plea, you waive your right to have a trial in the case?
Yes, sir.
You also waive your right to require the state to prove the charge or charges against you beyond a reasonable doubt?
Yes, sir.
Okay, and you still wish to go forward with a plea of no contest?
Sir.
All right, sir, I'll find your plea to be free and voluntary. Be clear thinking about all of this.
Yes, sir.
Had counsel standing there next to you, helping you out with this.
Sir. Yes, sir.
And so I'll accept your plea. You'll be adjudicated guilty of the charge. You're going to be sentenced to time served, which in your case is 3 days. And you're also going to be ordered not to return to the area wherein the alleged offense occurred. And that'll be for a period of 6 months. And then there's also court costs and the other attendant fees associated with your appearance here in court today, which I'll assess. I'll give you 30 days to contact the clerk's office to work something out on those. So, any questions, sir?
Good.
And you're all done. Good luck.
Right, brother.
Seems like a jolly fella.
How you doing, Your Honor?
Good. How are you?
I'm good.
All right, let's see. Who have we here? You are, what's your name, sir?
Jeffrey Brian Carpenter.
All right, Mr. Carpenter. The charges are, first one is a felony. It's battery by strangulation as an incident of domestic violence. That's count one. Count two is straight up misdemeanor domestic battery. Do you understand those charges?
Yes, sir.
All right. And I reviewed the affidavit. I do find probable cause for each of the charges. I don't see an affidavit of insolvency in here. Is it your intent to talk to a private attorney in this case?
Excuse me, say that again?
I said, is it your intent to talk to a private attorney about representing you in the case?
I don't know who's representing me. They asked me for a public defender, so.
He has the form he filled out for the PD's office already. I don't know if they have them at the, they might have them still at the desk back there. Can we check really quick? He already filled the form out.
Okay. Well, how's it look? Does it look like he qualifies?
He makes 800 every 2 weeks. How many dependents? Or one dependent, Your Honor. 800 every 2 weeks and one dependent, I believe.
All right, I'll go out on a limb and say he qualifies. So your desire is for me to appoint the public defender, correct?
Yes, sir.
All right. And so I'll go ahead and appoint the public defender. Good morning, ma'am. Your name?
Morning, Ann Bates. Good morning, my name is Ann Bates.
All right. You, let me check my thing. Ah, there we go. You're the named victim in the case.
Correct.
Yes?
Yes.
Yeah. I need you
Is
to
this
get
on?
close to that microphone.
Okay.
Yeah, just as close as you can get without being uncomfortable.
Yes.
Okay, thank you. So, what is he to you?
That is my partner and the father to our child.
Now, he's charged with a felony, which is battery by strangulation. And then there's also an attendant misdemeanor domestic battery associated with it. You've been sitting out there for a little while listening to what we've been doing. So you understand that what we're dealing with today are conditions of release for him.
Correct.
The conditions are designed for multiple purposes. The two most important, number one, would be to make sure that he appears for any court hearings and that sort of thing. But as important as that is the desire to protect you from any further violence. Do you understand that?
Yes, sir.
So, again, remember, getting close to the microphone, what would you like to see me do today?
I personally would like him to come home. We have a routine with our daughter. You know, I don't feel in danger by any means.
How old is your daughter?
She just turned 5 months.
Okay, so she wasn't really privy to anything that went on between
She was
you.
completely separate from the incident.
Okay. Now, he does qualify for what's called pretrial release, which is a monitored form of release. Doesn't require that he post a bond or put any money up, anything of that nature. But he does have to report to and periodically check in with PTR. What do you think about that?
I would love for him to come home in those conditions. I mean, if
So
that's
what
he qualifies for.
you're asking, and I'm not trying to steal your thunder on this, but what you're asking is that I release him with an order that he have no hostile contact with you.
I mean, I would like to be able to still live together, but
Okay, we're
yes, of
not to
course.
that part yet.
Okay.
But just up front of all of that is him being ordered to have no hostile contact with you, which means if there was any kind of hostility between the two of you and the police became involved, he would always be the one coming back over here.
I understand.
Okay. Now, as far as residency is concerned, you're asking me to allow him to come back to the house.
Correct.
Okay. And then, as far as alcohol and drugs and weapons and things like that, he'd be ordered to have none of that.
Understood.
Okay, would that work for you?
I mean, with your best judgment, I mean, he doesn't really drink or do drugs and he doesn't have weapons, so it's one of those things.
Yeah, it's just a precaution.
No, I understand for sure.
So that'll all work for you?
Yes, sir.
Okay, now the state may want to ask you a couple of questions, okay?
Okay.
All right. State, any questions?
I just have a couple. At this time, would you call law enforcement if there was another incident that occurred to you?
I mean, if necessary, but I don't foresee that being necessary.
Do you feel threatened?
No, ma'am.
And at this time, if he was to reside outside of the home and came to the home, would you call law enforcement?
Are you asking like if he was ordered to stay away from the home or
Yes.
under what? I mean, if that's court ordered, then I mean, yes, if I have to, but I
If
don't.
he's court ordered not to return to the home and he returned to your home, would you call law enforcement?
Yes, I would feel comfortable calling law enforcement.
No further questions.
All right. Well, based on the wishes of the victim.
May I speak? May I be heard?
Pardon me?
May I be heard on his?
Oh, yeah, sure. Go
Thank
ahead.
you. At this time, I would object to the pretrial release based on the affidavit that was presented to the court, based on victims' report to law enforcement about especially the restricted breathing with the tap out. Also, there is criminal history for this defendant. So I would just object to any type of pretrial release and ask the court to remain the bond to be set at a reasonable bond. However, no return to the residence, no hostile contact. I know they have a child in common, but no return to the residence.
Counsel.
Your Honor, given the victim's testimony here today that she's not in fear, he does not have a history of violence. I would ask for a pretrial release and a no hostile contact order. If the order is violated, he can be brought back here and held at no bond. There's a presumption in favor of non-monetary bond, so I'd ask for a pretrial release in this case.
Okay, I'm going to go ahead and authorize your release, pretrial release, because I think them monitoring you in the long run is a better circumstance than you just being out there on a bond unmonitored.
Yes, sir.
Which means any information comes to them about any further occurrences of this nature, or basically anything you do that might be against the law, would get you back over here, and as your attorney just said, with no bond.
With no bond, so I would get booked back in with no bond and sit until I go to trial, correct?
Or until the court orders otherwise.
Okay, I fully understand, sir.
All right, and based on the wishes of the victim, I'll order that you're to have no hostile contact with the victim, meaning if there's any hostility, you're the guy that's coming back here, right?
Yes, sir, I understand.
You're to have no weapons on or about your person as a condition of release. You're also to consume no alcohol or drugs not prescribed for you by your own physician.
Yes, sir.
And I see one of the things on your history is a possession of methamphetamine.
Yes, it was old.
Well, old or not anymore, right?
Yes, sir.
Okay. All right, good luck. Thank you. Thank you, ma'am. Good morning, sir. Your name?
Louis Loxley.
All right, Mr. Loxley. Do we have any victims in the case of Mr. Louis Loxley? None, eh? All right, Mr. Loxley, you are charged with sexual,
I will waive the reading.
all right?
To waive the reading of the charges.
Do you know what you're charged with? I'll let your counsel go over that with you for a second.
Yes.
So at this point, after speaking with counsel, you feel like you understand what you're charged with?
Yes.
All right. By the way, you do qualify for the public defender, so I'll go ahead and appoint the public defender for you. Now, State, correct me if I'm wrong. This is a PBL, right?
Yes.
All right. That means a punishable by life felony. All right? Now, typically, the court would at this point, finding probable cause for the charges, which I've done, that would be impose a no release on you. In other words, you be held here on no bond pending further order of the court. Do you understand that?
Yes, sir.
All right, counsel, I'm sure you want to be heard on that.
Your Honor, you do have the discretion to set a bond. He has no other, I see it out of state, but no convictions. Been in the Orlando area for over a year, so he has community ties. I believe and the offense, based on what I read, occurred allegedly a long time ago. The victims are adults at this point. If you do a no contact order and no contact with any person under a specific age, Your Honor, I think that would suffice as far as protecting against any further crimes, given he has no criminal history.
Well, I think given the circumstances, given the fact that it is a PBL, that the appropriate thing for me to do at this point, after having found probable cause, is to order that you be held no bond, sir. Now, that's pending further order of the court. You will be entitled to a bond hearing downtown fairly expeditiously, and your attorney will explain all of that to you. I'm also going to order that you're to have no contact with the victim or victims as a condition of release. You're also ordered to have no unsupervised contact with any person under the age of 18 as a condition of your release.
And Your Honor, on count 2, I believe it is, I just ask that you stay the bond that was set, as on that charge, I believe he's entitled to a bond.
Yep.
Thank you.
As to count 2, yeah, I'll stay the bond at $1,000 with the other conditions also appropriate to count 2.
Thank you, Your Honor. Have a nice day.
Good morning. What's your name?
Allison Norman.
Need you to speak up just a little bit.
Allison Norman.
All right, Ms. Norman, you are charged with aggravated assault as a incident of domestic violence. Do you understand that charge?
Yes, sir.
All right, and I do have an affidavit here that indicates you qualify for the services of the public defender. Would you like for me to appoint the public defender to represent you?
Yes, sir.
All right, finding you qualify, I'll appoint the public defender to represent you. I do find probable cause for the charge of aggravated assault. And so therefore, I'm going to set your bond at $1,500. You're going to be ordered to have no contact with the victim or victims. You're to maintain a separate residence from the victim or victims. You're to consume no alcohol, no drugs not prescribed for you by your own physician. You're to have no weapons on or about your person as conditions of release. Now, do you understand all of those?
Yes, sir.
All right, any questions you have, you want to direct to your attorney. If not, then this hearing is concluded.
All right, thank you.
You're welcome. Okay, good morning, sir. Your name? What's your name, sir?
Marty Underwood.
Marty, you pronounce it? Marty Underwood?
Yes, sir.
All right, Mr. Underwood, you got a series of charges here. First, in 2023 CF 6831, you're charged with aggravated battery on a pregnant person. Do you understand that?
Yes, sir.
All right. Any victims in this case that wish to be heard? It appears not. And then in 2023 CF 6832, you're charged with aggravated assault with a firearm on a pregnant person, aggravated battery on a pregnant person, and battery by strangulation, all 3 of which are felonies, as is the count in the other case. Now, do you understand what you're charged with?
Yes, sir.
All right.
Sorry.
Based on the affidavit, appears that you qualify for the services of the public defender. Would you like for me to appoint the public defender to represent you, sir?
Yes, sir.
All right, this time I'll appoint the public defender to represent you in both cases. One of those cases is in Division 16, counsel. The other one's in Division 15.
Thank you, Your Honor.
The latter is Division 15. Having found probable cause in 2023 CF 6831, the aggravated battery charge, I'm going to set your bond on that one at $2,500. Of course, you'll be ordered to have no contact with the victim or victims. You're to maintain a separate residence from the victim or victims. Consume no alcohol, no drugs not prescribed for you by your own physician. You're to have no weapons on or about your person. In 2023 CF 6832, as to the aggravated assault with a firearm charge, having found probable cause to each of those 3 charges, Your bond will be set at $5,000 on count 2. The aggravated battery on a pregnant person, you'll have an additional bond of $150. And as to count 3, you'll have additional bond of $150. The same conditions will be applied. That is, no contact with the victim or victims, maintain a separate residence from the victim or victims. You're to consume no alcohol, no drugs not prescribed for you by your own physician. You're to have no weapons on or about your person.
And Your Honor, they did reside together. Can he have a one-time return with law enforcement to gather any belongings?
Yeah, I'll authorize a one-time return in the company of a law enforcement officer for you to recover your personal effects only.
Your Honor, I have a question. Can you go through the bond amounts again? I think you said count 2, 5,000 and 150 on 3, but what about count 1?
No, count 1 was 5,000, count 2 was 150, count 3 was 150.
And it's no weapons, no alcohol.
Right. All the standard stuff.
And no contact with the victim.
Yes, ma'am. Good morning, sir. Your name?
Xavier Bradley.
All right, Mr. Bradley. By warrant, you're charged with 1 count of battery, which is alleged to be an incident of domestic violence. Do you understand that?
Yes, sir.
All right. The judge who reviewed the warrant found probable cause for the charge. And although that judge ordered no bond, I'll set the bond on that at $1,500. Now, you are going to be ordered to have no contact with the victim or victims. You're to maintain a separate residence from the victim or victims. You're to consume no alcohol, no drugs not prescribed for you by your own physician. You're to have no weapons on or about your person. Now, in addition to that, we have a separate affidavit charging you with possession of MDMA, possession of drug paraphernalia, possession of cannabis under 20 grams, and resisting officer without violence. Having reviewed that affidavit, I do find probable cause for that as well. Bonds will be $1,000 as to count 1, $100 each as to counts 2, 3, and 4. You do qualify for the public defender, so I will appoint the public defender to represent you if that is your wish, sir.
Yes, sir.
You'd like to have the public defender? Public defender is appointed. Now, you're out on bond from March 4th of this year. That case appears to have been assigned to Division 20, so the court will take no action on the out on bond, and I'll leave that up to the court in Division 20 to determine whether or not to revoke that bond and your conditions of release upon the filing of a proper motion by the state attorney's office. Do you understand?
No, sir, I do not understand.
What do you not understand?
What you had just said, I really couldn't like process it.
Do what?
Yeah. Okay, so okay, yes, ma'am.
And Your Honor, and then the battery, you didn't get there yet? The battery charge,
Yeah?
did we set?
1,500.
15? Okay, I missed that one. Thank you.
I just want to make sure I have it properly also. 1,500 for battery, count 1, 2, 3, and 4 were $100. Is that correct?
Each, yeah.
Each. And then count 1, what was the amount?
$1,000.
$1,000. Thank you.
You're welcome. Thank you, sir. You're welcome. Good morning.
Morning.
Tell me your name.
My name is Anicia Howard.
Okay. Get ready for Heartburn City, State.
I just got to find.
That's code for there's a problem with PC.
I just got to find the case.
Ms. Howard, you're charged with battery. And it's charged as a domestic battery. It's a misdemeanor of the first degree. Do you understand what you're charged with?
Yes, sir.
All right. I also have an affidavit here indicating that you qualify for the services of the public defender. Would you like for me to appoint a public defender for you?
No.
Huh?
No, sir.
No, you don't want a lawyer?
Do I have to pay for that?
There's a minimal fee. It's, I don't know, what, $50 or something?
Oh, yeah.
You don't think you need a lawyer?
I'm not sure. I've never been arrested before, so I don't know how this works.
When in doubt, go for the lawyer. That would be a good mantra for you to live by in case this ever happens to you again. If you're offered the opportunity to have a lawyer versus not having a lawyer, it's kind of like having gas in your gas tank, with or without gas. You're always going to go with gas, right?
Yes, sir.
Think of the public defender as the gas in your tank.
Okay.
And so having a lawyer is always better for you.
Okay.
All right, so you want one?
Yes.
You got one. Now, I see she qualifies for pretrial release. That's a good thing, because state, and it may be in my reading, but I read this affidavit, and what I saw was that basically she took a phone out of somebody's pocket, but I didn't see anything else in there that would indicate a battery.
I put a question by that.
Yeah.
I can email the officer to see, again, it looks like it was a petty theft of grabbing the car keys.
That's what I wrote down. I thought possibly theft, but maybe not battery. So here's what I'm going to propose to do. I don't have the victim here, so I think statutorily, without the victim being here, there are certain things I'm going to have to order. But I think I'm going to authorize a release, pretrial release. It probably would go that way even if we had better facts in the case. And order that she's to have no contact with the victim, maintain a separate residence from the victim, and of course, the standard no alcohol, no drugs, and no weapons on her about her person. So I hope I didn't give you a major case of heartburn over that.
No, I read through it.
It's good that you saw that.
Mm-hmm.
You know, because a lot of times you wonder if people actually read these things. And sometimes you're kind of going, but good. So, counsel, did you want to be heard on something?
No, Your Honor.
Okay, do you understand that's your lawyer standing next to you? And if you have any questions, that's who you want to ask?
Yes, sir.
Okay, well, good luck.
Thank you. Okay.
And good morning, what's your name?
Cheyenne Merrick.
Cheyenne?
Cheyenne Merrick, yes, sir.
Okay, Cheyenne. You're charged with battery.
I'm sorry, could you repeat that?
Yeah, you're charged with the crime of battery.
Yes, sir.
And it's charged as a misdemeanor. It's also alleged to be an incident of domestic violence. You do qualify for the public defender services. Would you like for me to appoint the public defender as your attorney?
Yes, Your Honor.
Okay, all right, so I'll do that. I'll appoint the PD for you. Now, you also qualify for PTR.
Yes, Your Honor.
So, good morning, sir. What's your name?
I'm Scott Merrick. I'm my father.
Okay.
Brian Merrick.
Yeah, I read the affidavit. There is probable cause in there for a battery, but you're the victim, so you can talk to me about this. What would you like to inquire about as to your daughter?
Well, the thing about my daughter is she's never got in trouble a day in her life. And we got there's family issues that deal with depressions. And I believe that my daughter was in a manic depression situation that night. I don't think that she tried to cause any harm. As you can see, there's no fear from her. But I think that she was basically just in a manic depression. She felt like she was being crowded with, why are you showing up so late at home?
She lives in your house, right?
She lives at my house, yes, sir.
And is it your desire that I let her come back there to live?
Yes, sir. Like I said, she's my daughter, and she's never been in trouble.
Okay, all right. I can order her release under pretrial release, which is that non-monetary form of release, which should be monitored by pretrial release, the pretrial release folks here. And also that she's to have no hostile contact with you or any other family members. And then, of course, no alcohol, no drugs, no weapons on her about her person, which would get her out of here today. So will that work for you?
Yes, sir.
Okay, was there anything else, sir?
My wife was telling me something about a program that she could, like, I guess, not just go to, that can basically erase these types of charges. 'Cause like I said, she's never been in any trouble.
I
She's
think you're
always been a
talking
good
about
girl. She's a veterinary technician.
diversion.
Yes, sir.
It's a diversion program?
Yes, sir. I don't want to
That's
see anything.
That's a decision that gets made later on,
Okay.
not at this point. I mean, occasionally, I have seen those things happen at this particular juncture of the whole thing. But
Yeah.
that's something that's gonna come later on. What we're concerned about today, two things. Number one, conditions of release, and number two, protecting the victims from any further violence. So.
Got you, sir.
But you think if I send her home with a no hostile contact order, that'll work?
Yeah.
And then just so she can hear me, and so that she'll know what potentially is in her future, and so that you will know if she comes home and there's any hostility and she's involved in it, she'll come back here. If the police have to get involved, they'll bring her back here every time. And when she comes back here, she's gonna be held no bond until the court orders otherwise. So she'll be here for much longer than just overnight. But, you know, it's kind of up to you and the family to police it. I mean, you gotta be willing to pick up the phone and call 911 if she gets out of control again. Hard to do, it's your kid, I understand. But at the same time, you got more to protect there than just yourself, right?
Yeah, I have my wife and my son.
There you go.
And we have our family.
Okay. So do you understand everything I've said, sir?
Yes, sir.
Do you have any questions about it?
Is she bonding out or?
No, she's gonna go out on pretrial release,
Okay.
and, which probably will be sometime this afternoon.
Okay, I have her brother here for her then.
So, we clear on that?
Yes, Your Honor.
You got a lawyer. I'm gonna order that you be released, pretrial release. You're to have no hostile contact with
Yes,
your
Your Honor.
father or any of the other people in the house. Any hostilities on your part, law enforcement gets called, you know what happens. You come back here.
I understand.
No alcohol, no drugs, not prescribed for you by your own physician, and PTR will monitor you.
Okay.
Make sure that you're complying with that. You're to have no weapons on her about your person. Any questions that you have in the meantime should be directed to your attorney.
Okay, thank you.
All right, any questions? That goes. Good luck. Thank you.
Thanks, Your Honor.
You're welcome. Thank you, sir.
Thank you.
Good morning.
Good morning.
What's your name?
Destiny Manaya.
Destiny Manaya?
Manaya.
Manaya, okay. Well, Miss Manaya, you are charged with battery. It's alleged to be an incident of domestic violence. I did review the affidavit. I do find probable cause for that. And I also see that you qualify for the services of the public defender. So would you like for me to appoint them as your attorney?
Yeah, it's fine, yeah.
All right, that's what I'll do. Appoint the public defender. Now, do we have any victims here in Miss Manaya's case? None? Or one?
Your Honor, we have, the mother, because the victim is autistic and the mother takes care of the victim could not appear, here today in court.
Okay, so hi, what's your name?
Juana Manaya.
Okay, I'm gonna ask you to get close to the microphone there so I can hear you.
Yes, sir.
Those are not state-of-the-art microphones. They're not microphones you'd ever find at a rock concert.
Gotcha.
So, sorry about that.
No worries.
So you are her mother?
Yes, and the
Okay,
victim.
and the victim here is another,
My son,
your son? Okay.
her brother, yes.
All right, and he's autistic, is that correct?
Yes, sir. I was asking to speak because I was hoping that she get released without anything and be able to go home. Because after this, I'm headed to city court to get an ex parte order for my son. The victim, he's bipolar and has been off of medicine. 4 weeks ago, I was the one walking around with a black eye because he assaulted me, and he refuses to seek medical help. So I'm hoping today after here to get an ex parte so I can get help for my son and for her to be able to come home. She has no other records, anything else. It's just we've
She
been
actually
walking on
qualifies
pins.
for pretrial release, which is a
We've been walking on pins and needles at home because of my son's condition. He's very aggressive and we can barely do anything at home.
But you're not in fear if she comes home?
Absolutely not.
All right.
No, we are fear at home with
You don't
him.
think she represents an ongoing danger to your son?
Not at all. It's
All right.
the other way around, to be honest.
I have no problem ordering that. Set it up for you that way, which would be, I'd order to have no hostile contact with you or anybody else in the house, your son in particular. And basically that, the other stuff, no drugs, no alcohol, no weapons, that kind of
Correct.
thing, okay? But
Yes,
let
sir.
her come home.
Thank you.
All right, anything else?
No, sir, thank
All
you.
right,
I have a question.
well, that is true. This is your first experience with this, huh? Not something you ever want to have to do again, eh? So what time did you come in to this facility yesterday?
6 p.m.
Okay, so last evening? All right, well, I'm going to authorize your release, pretrial release. Now, I am going to order that you have no hostile contact, no fighting with your brother, no fighting with your mom. Just, you got to maintain it, be cool, as some people would say. And you're not to consume any drugs or alcohol, drugs not prescribed for you by your own physician, and you're to have no weapons on or about your person. And how old are you?
23.
Okay, you're old enough to help your mom out with this stuff. How old's your brother?
30.
30? Okay, so he's a little older. Okay, that's tough, living with somebody that's autistic. We have that in our family. Not immediate family, but in the family. And it comes in so many different forms. Some high functioning, some not, that sort of thing. So I don't envy you that, but it's a good idea. Have you ever been to any kind of a group that deals with those related to a person with autism?
Oh, I didn't even know there was groups.
They exist. And you may want to think about looking that up because I read the affidavit and, there is probable cause in there for what you're charged with, but at the same time, there's extenuating circumstances, the frustration and that sort of thing,
Holding it in for days, trying
Yes.
to stay calm.
I understand. I would suggest that you think about one of those groups. In fact, the public defender's office probably can turn you on to them. And so you stay in touch with your attorney, make sure you make your court dates and all that sort of thing. And good luck. So,
Thank you, Your Honor.
did I say all the proper things? If I didn't, you could just assume I wanted to. Go ahead and put it down there. You never know. Let's see. Good morning. What's your name, sir?
Fabian
Fabian
Pacheco.
Pacheco. Okay. Mr. Pacheco, you are charged with battery. It's alleged to be an incident of domestic violence. Do you understand that charge?
Yes.
All right. And I see you qualify for the services of the public defender. Would you like for me to appoint the public defender to represent you?
Yes. Yes.
Okay, need you to speak up just a little bit, okay? All right, I read the affidavit, I do find probable cause for the charge. You do qualify for the public defender, I'll appoint the public defender to represent you. Now, here's an issue, do we have a victim out there in Mr. Pacheco's case? We do not. I don't believe that a person can be released on a non-monetary form of release unless there is a victim present to be heard from. That may be a little known fact, but I believe that's the way it works, so.
No, Your Honor, we release all the time on pretrial
Well,
release.
see, but that, you're saying we, I'm not included in the we. In my we world, and if you look at the statute, you find out, I think you will find out that the statute addresses the issue of the victim being heard on non-monetary forms of release. So I'm not going to authorize PTR, not having a victim present. What I will do is I'll set the bond at $500. Now, you, sir, are going to be ordered to have no contact with the victim or victims. You're to maintain a separate residence from the victim or victims. You're to consume no alcohol, no drugs not prescribed for you by your own physician, and you're to have no weapons on or about your person as conditions of release. Now, do you understand all that?
Yes.
Okay, do you have any questions? You want to direct them to your attorney?
Yes.
You have one now?
Yes.
A question?
Yes.
All right, counselor's going to come over there and hear your question.
He has no questions, Your Honor.
All right, thank you, sir. Good luck. A lot of PTR here this morning, huh, Robin? You've been busy. Too bad you're not working piecework. You know what that means, piecework? That's where you get paid for each individual thing that you do. The more you do, the more you get paid. So like if you were hanging sheetrock or something, they pay you per board. If you were doing piecework today, you'd be a wealthy woman. Good morning, sir. What's your name?
Andrew Smith, Your Honor.
Mr. Smith, good morning. You are, you're charged with battery. It's charged as a misdemeanor domestic battery. Do you understand that?
Yes, sir.
And looks like you qualify for the public defender. Would you like for me to appoint the public defender for you?
Sir.
All right, I'll appoint the public defender for you. And I did review the affidavit. I do find probable cause for the charges. And so that being said, good morning.
Good morning.
What's your name?
I'm Valerie Smith, Andrew's mother.
Okay, and who else do you have in there with you?
I'm his sister, really, Andrea Marilyn.
Good morning.
Najia Bruno, his girlfriend.
Girlfriend, sister, mom. Okay, who's gonna be the spokesperson for the group? Step on up there, Mom. So, the charge is a battery and it's delineated as domestic, so it has its own conditions usually as far as forms of release. I will tell you that Andrew qualifies for pretrial release, which is, you know, depending on how you look at it, is good or bad. Good in the sense that it doesn't cost anything. Bad in the sense that he gets monitored and has to stay in touch with pretrial release, check, you know, make sure he's not doing any drugs or alcohol, anything that the court's ordered him not to do. But he gets out, and he would get out today. So realistically, what I need for you to consider is, are you okay with him coming out without having to post a bond?
Yes.
All right. Now, the other thing is, he lives there with you all?
Yes, sir. With me.
So,
She lives in Miami. She's in med school.
okay.
She lives with us.
All right.
Girlfriend.
So he lives with you and the girlfriend?
Yes.
Okay. Now, what are your thoughts about him coming back there?
So I'm the only living parent, and I spend a lot of time with Andrew daily. Just so you know, I'm a licensed clinical social worker. I've worked in the community since 1994, and I'm also a registered nurse. And I'm not afraid of my son. I just feel like he made a bad decision to ingest 6 tabs of LSD. I'm very confident that he did not know who we were. And I just want to let you know, the first contact was initiated by me because he was attempting to jump over our banister in our house. We have a 2-story. And based on my professional training, when you do encounter someone who's under the influence, they may retaliate. So it was more of him trying to free himself from us, or I was not going to allow my son to jump over the banister and hurt himself. I felt like he thought he can fly at the time. So he's not a danger to us. He's always been a protector. His dad is no longer here. He passed away. He's always been a protector. He doesn't have a criminal history, and he's a college student. As a matter of fact, he had class today at 12 noon. He has a 4.0 right now.
Well, so your decision would be to have him come back to the house?
Yes, sir.
You want, okay.
And also, too, I want to, I have a contact, my colleague, and I know I'm not making this about myself, but I am 2 classes away from becoming a psychiatric nurse practitioner. So I do have a contact for him to receive residential treatment. I do believe it's more it's treatment for him that he needs. So I'm in contact with the behavioral health, admin health, my friend's corporate compliance there, my colleague.
You're being proactive.
Yeah, so I got 3. I just want him to choose, but I have 3 options for him, the best options, in my opinion.
Okay, good. Well, you're probably in the best position of anybody on the planet to arrive at those conclusions.
Thank you.
So let me see. Girlfriend, let's start with you. How do you feel about him being able to come back to the house?
I'm okay with it.
So you're not worried about it or afraid of him?
No, he's a good person.
Okay, all right. Just keep that LSD out of the mix, right?
Yes.
Okay. Now, sister, how about it? But you're living in Miami, right?
Yes, I am.
You're in medical school down there?
Yes, at FIU.
FIU. You know, FIU is becoming quite the institution.
Yes, it's grown a lot.
The latest bar results were released here within the last week. I saw it. And FIU had a higher percentage passing rate than did the University of Miami.
Wow, yes, I know the law school is nice there.
Yeah,
FIU.
Miami's been there a long time, a lot longer than FIU. But congratulations to FIU.
Thank you.
All right, so you're not, I mean, when you're here, you're just here visiting, is that correct?
That's correct.
So typically you and he are not living under the same roof.
Yes, that's correct.
Okay. What I would talk to you about is part of what I will order is that there be no hostile contact between him and any of the 3 of you. And then if it gets hostile, anybody makes the call, he comes back here, but hopefully that doesn't have to happen. So will that work for you?
Yes.
Is there anything else you'd like to add?
No, I just would like him to just get the help he needs and that we love him.
Here's a question for you as a budding doctor.
Yes.
Why do so many doctors, after practicing medicine for years, suddenly decide to go to law school and become lawyers?
I wish I had the answer. I don't know.
I know quite a few of them who have done just exactly that. In fact, when I was a freshman in law school, we had a 72-year-old retired gynecologist in our law class. Now, he was, going a little slower than everybody else, but he just said after practicing medicine all those years, he was always curious about the other side, and so he decided getting his law degree was the right answer. That's a lot of work.
Yes, it is.
Got a lot of work in front of you. Well, good luck with your career.
Thank you so much.
Wish you the best. So, Mom, I'm going to authorize his release PTR, order that there be no hostile contact between him and any of y'all. So that means he can come home. Should be out sometime this afternoon.
Thank you.
And also order that he consume no alcohol and no drugs not prescribed for him by his own physician, and that he's to have no weapons on or about his person. Okay?
Yes, we have a question.
Yes.
I think he had maybe no shoes. We have clothes for him. Can we leave? Is there any way we leave clothes for him when he? Because I don't think he have clothes to come out into the public in.
Clothes here?
Yeah, we have the clothes here. How can we get those to him? I'm sorry.
Well, when you go downstairs, I think you see the folks down,
They live in my.
speak to the people at the window to get his clothes to him?
I think I came here in like just boxers, sir.
I can't hear what you're saying.
I think I just came here in like boxers, just like boxers briefs.
Okay, so you want some clothes, huh?
Yeah.
So if they leave them downstairs, would that get to him? Okay. What room is it? Okay. They'll direct them as to where to go? Okay. So before you leave the building down there, there are some folks you can talk to and they'll direct you as to where you can drop off the clothes, all right?
Thank you. God bless.
Anything else?
That'll do it.
Well,
Your
good
Honor.
luck, lady.
Your Honor, I just have one question. I had another victim, Muhammad Cassius.
Yeah.
Does he live at the residence too? Are you gonna give it no hassle?
There's 4 victims, Your Honor, and I'm not clear of who all lives at the residence.
Yeah.
I'm not sure if the girlfriend is one, but there's a Muhammad.
Yeah, who is Muhammad?
Muhammad is my husband. He lives with me in Miami.
He's your husband? So he's here visiting as well?
Yes, he is. He's at work today, so he couldn't attend.
All right, does that clarify that for you, Robin? How about it, State? Does that clarify that for you?
Yes, and who is Valandria Marilyn?
That's me, his sister.
And you do not live in the residence?
That's correct.
And there's a Nija?
It's Najir Bruno.
Bruno. Do you live in the residence?
Yes.
So we have the Mrs. Bruno and Mrs. Smith are the 2 victims that live in the home?
All right, anything else, State?
Yes. My husband wasn't able to attend today because of work, but he did write a statement, but we left it in the car.
Oh, from Muhammad?
Yeah, we have a statement from him since he was not able to attend.
Hold on to that.
Okay, we'll do.
Thank you. All right, so we clear, sir?
Yes, Your Honor.
No more LSD, no more drugs. You test positive for drugs while you're out on PTR, they'll violate you. You'll get picked up again. You'll be brought back here. You'll have to go through this whole thing again, and the conditions of release will not be nearly as lenient as they are today.
Sir.
Understand? You be wise man. Listen to your mom. Sounds like your mom is got your best interests at heart. Incredibly intelligent lady, knows what she's talking about, works in this field, and even as close to you as she is, she knows the answers for you. You just got to listen, all right?
Sure.
Good luck. Thank you, ladies.
God bless.
Joshua Matthew Smith, is that you, sir? Okay. Let's see, all right, Mr. Smith, you are charged with battery. It's alleged to be an incident of domestic violence. Okay, and I do find probable cause for the battery charge. You also appear to qualify for the public defender's services. Would you like for me to appoint a public defender for you?
Yes, sir.
All right, I'll do that at this time. Now, hello, what's your name?
Hi, I'm Stephanie Pozeg. I'm Joshua Smith's wife.
Okay. So how do you pronounce your last name?
It's Pozeg. It's
Pozeg.
German.
Okay. All right. Well, as a victim, you know, I can tell you that he qualifies for pretrial release.
Yes, Your Honor.
So that's the first thing let's talk about, that being that, you know, you as a victim have a right to be heard as to whether or not you think pretrial release is the proper way to let him go.
Yes, I do believe so.
You good with that?
Yes, sir.
Okay. Now, the two of you are living together, is that correct?
Yes, sir. We've been married for 3 years.
Okay. And Is it your desire that he be allowed to come back to the house?
Yes, sir.
So you want him back there living?
Absolutely, Your Honor.
You're not in fear of him?
No.
You see this as an isolated incident?
Yes, Your Honor.
Okay. All right. Well, State, you want to ask any questions of the witness?
Yes. If another incident occurred, would you call law enforcement?
Absolutely.
If he was ordered to reside outside the home and came to the home, would you contact law enforcement?
Absolutely.
No further questions.
All right. Okay, sir, I'm going to authorize your release, pretrial release. You're going to be monitored now. I'm going to order that you have no hostile contact with the victim. That means you can go home, but any hostilities, you come back here. You're ordered to consume no alcohol, no drugs not prescribed for you by your own physician. You'll be monitored by pretrial release to make sure you're complying with that court order. You're to have no weapons on or about your person. Do you understand?
Sir.
All right, now, if you have any questions, you want to direct them to your attorney there, and good luck. Thank you, ma'am.
Thank you so much. God bless.
Yep, you're good.
Good morning. What's your name?
Megan Vasquez?
Good morning, Ms. Vasquez. You are charged with battery.
Yes, sir.
It's a misdemeanor domestic battery. Do you understand that?
Yes, sir.
All right. You do qualify for the public defender. Would you like for me to appoint the public defender for you?
Yes, sir.
I'll do that at this time. Finding you qualify. I guess our room is empty out there now.
Yes.
Yeah, okay.
Qualifies for pretrial release, Your Honor. I'd ask for pretrial release. I was reading the statute. I don't see where it states that if the victim is not present, pretrial release cannot be authorized.
It's not pretrial release specifically, it's non-monetary form of release. I'm not sure why, but. So here's what I'm gonna do. I'm gonna set your bond at $500. You're gonna be ordered to have no contact with the victim. You're to maintain a separate residence from the victim. You're to consume no alcohol, no drugs not prescribed for you by your own physician. You're to have no weapons on or about your person. Now, the most important thing for you is that you have an attorney. If you have any questions, you want to direct those to your attorney.
Yes, sir.
Understand?
Yes, sir.
Okay, good luck.
I have a question, Your Honor. Are you allowing the defendant to reside with the victim, or are you saying separate?
No, it's no return. And good morning, sir. What's your name?
Daquan White.
Mr. White?
Yes, sir.
I'm looking at an affidavit that is attached to a warrant for your arrest, charging you with domestic battery. Do you understand that?
Yes, sir.
All right, sir, probable cause was established by the judge who signed the warrant. And now you do qualify for the services of the public defender. Do you understand that?
Yes, sir.
Would you like for me to appoint the public defender for you?
Yes, sir.
All right. This time, the court will find you qualify and appoint the public defender for you. Let me see what this warrant says.
Excuse me, sir.
Actually, I've appointed the public defender for you, so you probably want to hold your comments till you have a chance to talk to your attorney.
Yes, sir.
All right?
Sorry about that.
Okay, well, I'm going to set your bond at $1,500. I'm going to order that you have no contact with the victim or victims.
Yes, sir.
I'm going to order that you maintain a separate residence from the victim or victims.
Yes, sir.
You're going to be ordered to have no or consume no alcohol, no drugs not prescribed for you by your own physician. You're to have no weapons on or about your person, sir.
Yes, sir.
Now, there's your attorney. If you have a question, you may want to ask your attorney. Good luck, sir.
Thank you, sir.
You're welcome. Morning, sir. Your name?
DeAndre Anderson.
All right, Mr. Anderson, you got an out-of-county warrant out of Lake County. The charge there is first-degree murder. Do you understand that?
Sir.
All right. Well, Lake County being contiguous to Orange County, we generally give contiguous counties 24 hours to come and get you. And then if they don't comply with it, is it still 24 and 72?
Yes, Your Honor.
Okay. 24 for contiguous counties, so if that doesn't occur within that time period, you'll be coming back before the court so we can talk about what we're gonna do. But I suspect they'll be here to get you. They're probably down there waiting for you now.
Yes, sir.
So, good luck. Morning, sir. Your name?
Enrique Martinez.
Mr. Martinez, you're being held on an out-of-county warrant out of Broward County.
Yes.
Charges, looks like a violation of community control for trafficking in methamphetamine.
Yeah.
The court in Broward County issuing the warrant has directed that you be held no bond pending their coming to get you. That not being a contiguous county, we give them 72 hours.
I have a VOP hearing set for tomorrow already.
Yeah, you better get in touch with somebody and have them let the court know. But whoever signed this warrant, it's probably the same judge that you're on community control with. So the judge is gonna know it, it's gonna be right there in the file. The judge may or may not know you've been picked up here. So if there's somebody you can contact to make sure they know on that end that you're in jail here,
Okay.
then that's probably the best you can do.
All right.
Good luck.
Thank you.
You're welcome.
Yana Kibana Matthews is on medical.
Medical, okay, so,
Defense will waive.
huh?
Defense will waive.
Well, okay, that's a Seminole County warrant by my good friend Mark Herr. With a $1,000 bond on a driving while license suspended charge. So, there we go. That's a done deal.
He has two more, I believe. Three of them, three Seminole let me see.
Does he?
Three. It was three of them. He has two bonds and one no bond. Let's see.
The one I just did?
Yes, the $1,000 one was for 23357 CTA, and she also has a 23737 CTA. With that bond is $495, and then she has another case 22241 MMA, and that's a zero bond.
Okay. All right, now we got all that on the record. We're good.
Yes, Judge.
Thank you. Good morning. What's your name?
Deborah Woodard.
This one? Oh, yeah. Got it, okay. You know, it's very easy to get confused when you're a senior citizen like myself. Good morning, what's your name?
Deborah Woodard.
Deborah Woodard. I have a good friend in Seminole County who's a judge, John Woodard. Nice guy, probably the best judge in the state of Florida. You're being held on a warrant also out of Alachua County. And that's for a failure to, or a VOP, I guess, on a theft charge. And that court has ordered that you be held no bond pending further order of that court. You understand? Okay. So that's not contiguous, so they got 72 hours to come and get you. All right? Any questions?
No.
Good luck.
Thank you.
You're welcome. Good morning, sir. Your name?
Ahmad Butler.
Mr. Butler, you're being held on a violation of probation charge in Division 14. The violations alleged are fail to report to probation, March, April this year, fail to successfully complete or remain in drug or alcohol treatment, failure to successfully complete 100 hours of community service. Do you understand the violations, sir?
Yes, sir.
All right, now that court has ordered you held no bond on the VOPs pending further order of that court, which probably means that you'll be seen next week here in Courtroom 3 by Judge Lattimore on the initial things that need to be done with the VOP. So, any questions?
So no bond, right?
Yeah, no bond.
All right.
It's pretty standard with the felony VOPs. So, good luck with that.
All right. Thank you.
You're welcome, sir.
Good morning.
Is there affidavit in there? Nope. Well, maybe I ought to. I'll go ahead and appoint the PD on that VOP. Let's see, your name, sir.
Brian Harry Prasad.
All right, Harry Prasad, Mr. Harry Prasad. You're being held on a violation of probation. That's in Division 82. The violations alleged are committed new offense of aggravated assault with a firearm as an incident of domestic violence. Do you understand that?
Yes, sir.
All right, well, can you afford an attorney, sir?
I have to speak to my uncles.
Huh?
I have to speak to my family.
Okay, so you're gonna try to get a private attorney?
I'm not too sure of my situation. I thought I was gonna bond out yesterday.
Well, you're being held no bond on the VOP. So, you want me to appoint the PD for you, just to be on the safe side?
Is that? What is the PD?
Public defender.
No.
No? Okay, I'll put you down as you're gonna get your own lawyer.
Okay.
And, you'll be held no bond pursuant to the warrant. Your warrant says in there, no bond, not to be modified at initial appearance.
No bond.
No bond.
So if I have a private attorney, can I get a bond?
Your private attorney can always request a bond,
Right.
but that'll have to go to the judge in Division 82, which appears to be Judge Wish. Is she still a county judge, or did she get appointed circuit? Still county.
Do you know when I'll have the court for that?
No, sir. The only person that'll know that at this point is your attorney.
So how long do you think I will be here?
I have no idea, sir. There's no way to predict that because every court works differently.
My situation, I shouldn't be here. Well, I'm pretty sure everyone says that.
I understand your confusion, but if you're gonna talk to a private attorney, that's who you wanna listen to.
Right. It's just, I'm stuck in here. I don't know how I
You are stuck here for now.
Right. I don't know how I could fight this inside here.
I can't hear you.
I don't know how I could get my hands wrapped around the situation from the inside here. I don't have anybody on the outside.
That's
like
why you
family.
wanna speak to an attorney, sir.
Right.
Your attorney then becomes your representative
Right.
out there
Right.
to work on getting you out of here.
Exactly. I don't have funds. I have to rely on my
Well,
family.
you've told me you don't want me to appoint the public defender, so it's one or the other, private attorney or public defender.
How long would I have to wait for the VOP court?
Sir, I don't know the answer to that. Good luck. Thank you. Guess if you ask that question often enough, maybe you get an answer. What's your name, sir?
Timothy Justin Stovall.
Mr. Stovall, you are, oh, there you are, charged with, well, you're being held on a violation of probation in Division 14. You understand that? The violation, I need you to use your voice.
Yes, sir.
All right. Violations alleged are you changed your residence without the consent of probation. Your whereabouts were unknown as of April 1st of this year. Also that you failed to work diligently at a lawful occupation, failed to report to the clerk's office within 30 days to set up a payment plan, and failed to successfully enter and complete drug and alcohol residential treatment. Do you understand those violations? All right, now, this is probably not going to come as a shock to you, but got to say it for the record. The court that signed the VOP, that is the court where it's pending in, has ordered that you be held no bond pending further order of that court.
Yes, sir.
Any questions? Good luck. Good morning. What's your name?
Morning, Millicent Marshall.
All right, Ms. Marshall, you are being held on a violation of probation as well. And that's in Division 84. The violations alleged are you changed your residence, and that as of September 5th, 2009, your whereabouts were unknown, that you failed to make full and truthful written reports to your probation officer in September 2009, that you failed to keep scheduled initial group intake appointments September 1st, 2009, that you failed to pay cost of supervision, currently $80 in arrears, and that you failed to enroll in a substance abuse evaluation within 60 days of the court's order. Now, the court in Division 84 has ordered that you be held no bond. You do qualify for the public defender. And so with your permission, I'll appoint the public defender to represent you.
Yes, sir.
All right, public defender is hereby appointed. Good luck to you, ma'am. 2009, that's kind of goes back their ways, don't it? That was back when me and you both had hair. But we're okay with it like this, you know? We've already determined that, haven't we?
That's the one you were looking for in the beginning you couldn't find, and I gave you the paper.
Okay, we've got some 33-day motions.
Bridget?
First case is Angel Luis Figueroa Rivera, case number 23 CF 5161AO. It's a 33-day motion. What says the state?
I'm pulling up the email really quick. Which case, Your Honor? Angel
Luis Figueroa Rivera.
Your Honor, this time it looks like information has been filed this morning at this time, so no ROR.
You said information was filed, right?
Yes, this morning, 8:42 a.m.
Okay, so denied as to the release on the 33-day motion.
Don't worry about it.
Next up is Andres Philippe Benjumia.
Your Honor, there was a motion filed to extend defendant's custody for 40 days.
When was that filed?
I didn't get that, Your Honor.
That was yesterday afternoon.
Defense would object, Your Honor.
It looks like on the 18th, I'm sorry, May 18th, 2023.
Has the motion been heard?
Not to my knowledge.
Counsel, you have anything on that?
I do not, Your Honor.
And I'm just gonna pull it up in our system really quick.
What was that name for the extension?
It's Andres Philippe Shalark A. Benjumia. I could spell it for you if you want.
I have the case number, Your Honor. I'm gonna double check, but I wasn't sent over a motion for extension. If I have a moment to see.
It looks like the information was filed yesterday also.
There was an information filed, Your Honor. I don't know where the motion came from.
Well, denied. All right, next up is Christopher Antoine Jones.
It looks like no information was filed yesterday.
So the motion will be granted.
I'm just making sure.
Next up is Joshua Temple.
I'm sorry, Your Honor, I'm just making sure that I'm going through. Notice of non-filing was filed yesterday.
All right, that motion will be granted. Next is Francis Schaefer.
I have a notice of no information was filed.
All right, that'll be granted. And next up is Daniel Estavo Miranda de Carvalho.
I have a no information notice filed.
All right, granted. Clarence Oliver.
Clarence Oliver. I have a no information was filed.
Granted. And Elijah Wayne Lofton.
I have a notice of non-filing.
Granted. Kimoi Akeem Fields.
It was, information was filed yesterday.
Denied. Yeah, what else we got, Madam Clerk? That it? Okay, what do y'all think about, you want to do 12 again? 12:30, okay. We'll do 12:30. So we'll come back at 12:30 and do session 2.
Come on up.
Good afternoon, Your Honor. This is Rafael Barrera, State Certified Court Interpreter. I have been previously sworn.
Good afternoon, Ms. Barrera. This is Judge Arendis. We are in Osceola in courtroom 4D, handling initial appearances. It is going through the courtroom to the jail, but they've reported that it's kind of low over there, so they might need you to repeat. I just wanted to give you a heads up about that.
Thank you, Your Honor.
We do have a couple cases for you. The first one is going to be 23 CF 1547, Abraham Borgen Guante. He is at the microphone. Good afternoon, sir. State your name and date of birth, please.
Buenas tardes, caballero. Por favor, dígame su nombre y su fecha de nacimiento. Despacio, voz alta.
Abraham Borgen Guante, 09-25-89.
Clarification, Your Honor. Abraham Borges Guante, 25 de septiembre 89.
Sí.
Abraham Borges Guante, 25th of September 1989.
Sir, you've been picked up as a result of battery, domestic violence by strangulation.
Señor, usted ha sido detenido por un cargo de agresión física, violencia doméstica, estrangulación.
Sí.
The court
Yes.
has reviewed the charging affidavit. I do find there's sufficient probable cause.
El tribunal ha revisado la acta acusatoria y determinamos que existen indicios razonables.
Bond to be set in the amount of $5,000.
La fianza será programada en $5,000.
You are not to return to 233 Old Bay Lane in Kissimmee.
No se le permitirá regresar al 233 Old Bay Lane en Kissimmee.
You can go back one time with the assistance of law enforcement to obtain your personal items only.
Se le permitirá regresar una sola vez acompañado de un agente del orden público para recopilar sus pertenencias personales.
You're not to have any contact with Indira Silva.
No se le permitirá tener contacto con Indira Silva.
No contact means no in-person contact.
Eso se le prohíbe contacto personal
No third-party contact.
por terceras partes,
No social media contact.
por redes sociales,
No telephone contact.
contacto telefónico,
No video contact.
contacto por video,
No contact whatsoever. Do you understand?
prohibición de contacto en absoluto. ¿Entiende usted?
Una pregunta. Ella
I have a
no vive
question.
ella no vive en esa casa. Ahí
She
fue
doesn't live at that
yo
house.
vivo solo.
I live alone.
Well, I don't have that information, so it will need to be provided to the state, but you're not allowed to go back to that house at this time.
Esa información no la tengo yo, se la tiene que usted que proporcionar a la fiscalía, pero en este momento no se le permite regresar a esa dirección.
Okay.
Okay.
Now, do you understand what no contact means?
Entonces, ¿usted entiende lo que quiere decir la prohibición de contacto?
Sí.
Yes.
Thank you. You may have a seat.
Gracias, puede tomar asiento. Próxima comparecencia cuando sea programada.
Next case, 2022 CT 4045, Roberto Arocho.
PD appointed.
¿Tiene el defensor público?
Good afternoon, sir. State your name and date of birth, please.
Buenas tardes, caballero. Por favor, dígame su nombre y su fecha de nacimiento. Despacio, voz alta.
Roberto Arocho, 81474.
Roberto Arocho, 81474.
Sir, you've been picked up as a result of a warrant for violation of probation.
Señor, usted ha sido detenido por una orden que fue emitida por incumplimiento de libertad vigilada.
There's no bond on that.
No tiene derecho a fianza en este momento.
Thank you.
Gracias.
Next court date, June 1st, in courtroom 4A at 8:05 a.m.
Próxima comparecencia, 1 de junio, sala 4A a las 8:05 de la mañana.
Thank you, sir. You may have a seat.
Puede tomar asiento, señor.
Hector Cruz Aponte, 23MM1232 and 23MM1233.
PD appointed.
Se le designa el defensor público.
Good afternoon, sir. State your name and date of birth, please.
Buenas tardes, caballero. Por favor, dígame su nombre y fecha de nacimiento. Despacio, voz alta. Héctor Cruz Aponte, May 13th, 71.
Sir, you've been picked up on two different matters.
Señor, usted ha sido detenido por dos asuntos diferentes.
The first one is a petty theft.
El primero es hurto menor.
The court has reviewed the charging affidavit. I do find there's sufficient probable cause.
El tribunal ha revisado la acusatoria y determinamos que existen suficientes indicios razonables.
You do not qualify for pretrial release.
No reúne requisitos para la libertad provisional.
Bond on this matter would be set in the amount of $250.
La fianza en este asunto será programada en $250
And you are not to return to the Coles.
y no se le permitirá regresar a la tienda Kohl's.
Additionally, there's a petty theft charge
Adicionalmente tiene otro cargo de hurto menor
on a separate date.
en una fecha diferente.
The court has reviewed the charging affidavit.
El tribunal ha revisado la acta acusatoria.
I find there's sufficient probable cause.
Determino que existen suficientes indicios razonables.
Bond to be set in the amount of $250.
La fianza será programada en $150
And you're not to return to the Coles.
y no se le permitirá regresar a la tienda Kohl's.
Thank you, sir. You may have a seat.
Muchas gracias, caballero. Puede tomar asiento.
Next court date on demand.
Próximo en comparecencia cuando sea ordenada.
Ms. Anderson, does it sound better over there? Okay, thank you. Mr. Barrera, would you mind making an announcement to make sure that we haven't missed anyone?
Certainly, Your Honor. Su atención, por favor, si hay alguna persona presente que necesite los servicios del intérprete, por favor, alce la mano en este momento.
Your Honor, we have two more. Can you give me their names?
We have, I'm sorry, it's one more. Her name is Marbelis Gloria Delmar.
PD appointed.
Se le designa el defensor público.
Oh, I just pulled the wrong one. Oh, there she is, all the way in the back.
The other one that you pulled is actually Mr. Quinones' case, if you want to have that to the side, just so you have it there too. I don't understand.
Good afternoon, ma'am. State your name and date of birth, please.
Buenas tardes, señora. Por favor, dígame su nombre y fecha de nacimiento. Despacio, voz alta.
Marbella del Carmen, Viloria del Mar, 5 de marzo de 1980.
Marbella del Carmen, Veloria del Mar, 5th of March, 1980.
Ma'am, you've been picked up as a result of driving under the influence.
Señora, usted ha sido detenida por el delito de conducir bajo los efectos.
The court has reviewed the charging affidavit. I do find there's sufficient probable cause.
El tribunal ha revisado la acta acusatoria y determinamos que existen suficientes indicios razonables.
You do not qualify for pretrial release.
Usted nos reúne requisitos para el programa de libertad provisional.
Bond to be set in the amount of $500.
La fianza será programada en $500.
You're not to possess or consume any alcohol or drugs.
No se le permitirá poseer o consumir drogas o alcohol.
Thank you.
Muchas gracias.
Next court date, if still in jail, June 1st. If out, June 12th in courtroom 4A at 8:15 a.m.
Próxima comparecencia, 1 de junio, si está detenida. 12 de junio, sala 4A, 8:15 de la mañana, si está en libertad.
Ms. Anderson, is that the last one over there?
Yes, Your Honor.
Thank you.
Your Honor, the interpreter can respectfully request the case number for this last defendant, please.
23 CT 2383.
Thank you, Your Honor. Have a good afternoon.
Thank you, Mr. Barrera. You too. Marlenis Rodriguez. Ms. Anderson, we have private counsel over here, so you can stand down. Parents for the record.
Attorney John Quinones on behalf of Marlenis Rodriguez.
Thank you. It's 23MM1235. Good afternoon, ma'am. State your name and date of birth, please. Thank you. Ma'am, you've been picked up as a result of battery, simple touch, or strike associated with a domestic situation. Mr. Quinones, did you wish to be heard as to probable cause or as to release restrictions?
At this point, just to release restrictions, and I believe the alleged victim is here not wanting to prosecute and say a few words, but that's what we would ask, that she be released. She did reside in that premise with the alleged victim. He's asking for no hostile contact, but in the alternative, the mother is here and she does have a place that she can remain.
Okay. Well, I am going to find probable cause by my review of the charging affidavit. Mr. Rodriguez, did you wish to be heard? No, not heard. Did you wish to be heard by the court? Okay. I have reviewed the charging affidavit. I was intending on, you can have a seat, sir. I was intending on ordering no hostile contact anyway, given the circumstances of the affidavit. Ms. Rodriguez, if you are around your father and you find that you're getting upset with him or with anything in any way, shape, or form, you need to remove yourself from the situation. Because if you do not and the police are called, you're the one coming back to jail for a violation of the no hostile contact. Do you understand? Thank you. And bond to be set in the amount of $500. I'm not ordering pretrial release. It's just a straight bond.
Thank you.
Okay. Thank you.
Next court date on demand.
James Lupo.
President Fortune.
Good afternoon, sir. State your name and date of birth, please. Thank you. Mr. Lupo, you've been picked up as a result of a warrant out of Indian River County for case 2021-1276. Sir, there's no bond on that. We will let them know when you're ready for pickup. Thank you. 2016 MM132, Ishtar Burgos.
We have attorney on record as Courtney Daly.
President Fortune, Your Honor, she advised she has private counsel on this case. No one's here at the jail. I'm not sure if someone's at the courthouse.
No, I don't have anyone here either. Ma'am, do you wish for me to move forward without your attorney being present, or would you like me to reset it for tomorrow to give them the opportunity to be here?
I'm not sure what the right answer to that is, ma'am. I think I'd like to move forward.
Okay. State your name and date of birth, please.
Ishtar Burgos, September 20th, 1970, ma'am.
Thank you. Ma'am, you've been picked up as a result of a bench warrant for failure to appear for a violation of probation arraignment. There's no bond on that. Thank you.
Next court date, June 1st, in courtroom 5B at 8:30 a.m.
2023 CF2, Joshua Aaron Cates.
PD appointed.
Good afternoon, sir. State your name and date of birth, please. Thank you. Sir, you've been picked up as a result of a warrant for failure to appear for arraignment. The bond is set at $2,500. Thank you.
Next court date, June 1st, in courtroom 4F at 8:30 a.m.
23 CT 1969, Rocky Vernon Little Davis.
PD appointed.
Your Honor, he bonded. Okay. 2022 CT 3652, Roberto Dennis Sadie.
PD appointed.
Good afternoon, sir. State your name and date of birth, please. Thank you. Sir, you've been picked up as a result of a warrant for failure to appear for a pretrial with the Public Defender's Office. There's no bond on that, sir. Thank you.
Next court date, July 26th, in courtroom 4A at 8:15 a.m.
Gabriel Langley, 23 CF 1548.
PD appointed.
Good afternoon, sir. State your name and date of birth, please. Sir, you've been picked up as a result of aggravated assault with a deadly weapon without intent to kill. The court has reviewed the charging affidavit. I do find there's sufficient probable cause. You qualify for pretrial release with a bond. That bond will be set in the amount of $5,000. You are not to return to 2626 North Beaumont. You may go back one time with the assistance of law enforcement to obtain your personal items only. You're not to have any contact with Henry Jones. No contact means no in-person contact, no third-party contact, no social media contact, no telephone contact, no video contact, no contact whatsoever. Do you understand? Additionally, you're not to possess any weapons or firearms. Thank you.
Next court date on demand.
Matthew Payton, 23 MM1234.
PD appointed.
Good afternoon, sir. State your name and date of birth, please. Thank you. Mr. Payton, you've been picked up on 3 charges. The first is battery, simple touch, or strike. Then you have a retail petty theft and resisting merchandise return. The court has reviewed the charging affidavit. I do find there's sufficient probable cause with regard to each count. Bond is going to be set as follows: $500 on count 1, $500 on count 2, $100 on count 3. You are not to return to the CVS. Thank you.
Next court date on demand.
Mr. Rodriguez, you're free to go if you'd like to go. Yeah, you can go if you want. You don't have to stay here. Okay, but Mr. Rodriguez, I don't control that. The state attorney's office controls that now. So if you want to go down and speak with them, you can talk to an advocate with their office and let them know what your intention is. Okay? Thank you so much. You're welcome. Kimberly Varnum, 23 MM1236.
PD appointed.
Thank you. Good afternoon, ma'am. State your name and date of birth, please. Thank you. Ma'am, you've been picked up as a result of resisting arrest without violence and providing false name or ID by the arrestee. The court has reviewed the charging affidavit. I do find that there's sufficient probable cause as to each count. Bond to be set as follows: count 1, $500, count 2, $500. Thank you.
Next court date on demand.
I just have a question. Yesterday, I talked to a bondsman. They said they were proceeding with the bond, that my person was there, and I haven't heard anything since then.
I have no control over that, ma'am.
Okay, thank you.
Thank you. Sanderson, did we miss anyone over there today? Thank you. Have a good afternoon.